Back to mention item number 30, Lordship, of daily list.
30.
30. I want to withdraw this Lordship. Kindly allow me to withdraw.
You want to withdraw this one?
Yes.
30. Rana, withdraw koro please. Okay, it will be disposed of on withdrawal.
Legal list. Let's go back to mention the listing of matter. Bail application. Let's arrested on 94, 24, 25. Maybe taken up on Monday. We have filed yesterday in the morning.
Monday.
Regular
Monday is 5th. And
for motion. For motion.
No, motion nowadays in motion too we are hearing the matters in all motion.
CD is required to be called on
Tuesday. Tuesday.
Right, please, Lordship. Lordship, I beg to mention item number 24, Lordship.
24.
24. The POCSO matter should be instead of the taken to the restaurant number 2, that is the informal Lordship. But the service report is awaited, Lordship, as per office note dated 34/2025.
You don't know whether here is a charge sheeted case or what? Charge sheeted.
It's just taken to the restaurant number 2, that is the informal Lordship. But service report is awaited, Lordship.
No, service is awaited very soon. It to charge sheeted case, no? I keep eyes in it. Key call for us. Oh, just charge sheeted case. Case diary call for. I don't know. You need to go on. Whether it is a charge sheeted case, huh? And copy of the case record along with the case diary be called for. Service be awaited till next date of listing. List accordingly, yes. Usami.
21st of May.
21.
Obliged, Lordship. May I please, Lordship? Lordship, with the consent of the other side, I beg to mention item number 38, Lordship.
38.
Excise department is in the other side, Lordship.
Huh?
Excise department is on the other side, Lordship. We have taken the consent, Lordship. Can it be taken up after 3 weeks, Lordship?
After 3 weeks. With the consent of the other side, learning council for the. But just a second, in item number 38, whether CD is available?
38, Lordship.
Oh, acha, sir, you are not there. Are you on interim there?
Yes, Lordship.
You are on interim? Are you sure?
Yes, yes.
Standing on the excise department.
Yes. Standing council excise department. With the consent of the other side, the learned council for the petition, paid for an adjournment. Prayer allowed. CD to action 9 Adano. Interim list after 3 weeks. Interim be continued till next date of listing.
Hello.
Hey, please, Lordship. Lordship, beg to mention item number 39, my lords.
Item number?
39, my lord.
39.
Ornament. My lord, may kindly take up this matter to my lord for upgradation and mention, my lord, this matter.
Whether the other side appeared here?
My lord, dusty service has been taken, but no wakalatnamas until today has been filed, my lord. So no one is.
Today file.
No, they have not filed.
They have not filed.
They have not filed, but dusty steps has been taken. Affidavit to that effect is also filed. Lord, as per your convenience, that's 2, my lord.
One more matter is there. We are not going to, it is a hearing or matter, no.
No, my lord, no, it's not. Slight intervention of my lord is required in this matter, my lord.
Pardon?
Slight intervention of my lord is required in this matter.
Intervention is what kind of intervention? Your matter is that if you need some modification of the order.
Yes,
If that is there, then the entire matter will be disposed of.
Yes,
What one day? We are not going to hear till the other side appear.
my lord,
Because it is a case.
taken, but until today they have not appeared, my lord.
No, whatever.
Steps are taken, my lord.
Yeah, I'm not going to hear. It may be fixed at 2. That is the issue. But we are service be awaited. We'll produce the case record. You want to fix that at 2? 2 hour hetu matter ase na? 2 matter?
Same related methods.
Oh, 2 matters are there. It will basically okay then. We are cleaning.
We have Lordship for listing the bail application, regular application earlier listed and the POCSO after 1 week, but 3 years already gone. The commercial quantity.
CD was?
The 3 weeks already gone, not listed. The commercial quantity. The 2 years ago, Lordship, already gone.
Maybe on Tuesday. Tuesday.
See, the lost.
As per instruction of one of my lord, I beg to mention item number 25 and 29. This matter-
25 and 23.
20. This matter may be passed over for that day, my lord.
29.
25 and 20.
29
Acha.
may be passed over for that day, my lord.
And both are most probably charge sheeted case. For the day means it will go
It usually come, my lord.
after 1 week. Okay. After 1 week. If you want any date, then it will go beyond 21, 22. Not before that.
Passed over for that day, my lord.
Pardon?
Passed over for that day, my lord. As usually it will come, my lord.
After 1 week. Take it up. 25 and 29. no? 1 week for it. And on the request made by so and so. Okay. Oh,
May it please your lordship. Lordship, I beg to mention item number 16 and 17. Lordship, kindly pass over for the day, lordship.
same here. We have received the LCR here.
Lordship, NDPS charge sheet method, commercial quantity, lordship. We need time for some preparation, lordship.
As Mr. Said, otherwise it will be after 1 week, or if you insist it for that, then it will be on either 22nd, 21st, or 22nd of May.
Pass over for the day, lordship.
Okay, list after 1 week. We do. As on a date to be fixed by the registry. Okay.
Obliged, lordship.
My pleasure, Lordship. I beg to mention item number 6, Lordship. Lordship,
Yes.
in this case, we have filed an additional affidavit. It may be called for, Lordship.
Additional affidavit. Okay.
Highly obliged.
May I please your lordship, I beg to mention bail application number 55 of 2025. Matter was fixed on today, my lord, but unfortunately.
Where is,
matter was
where
not
is the
listed.
list, item number?
My lord, no item number. my lord. I bail application number 55 of
No,
2000.
whatever, item, you want to listing?
My
Acha,
lord.
acha.
Today was fixed, my lord,
Ah.
but matter was not listed, my lord. Already,
We curtail some matters, in fact.
so my lord, matter may be come on Monday, my lord.
No
My lord,
chance.
already 3 numbers of accused person are allowed to go on.
No
bail by
chance.
this
Monday is not at all possible.
Then my lord,
Monday,
at least,
Tuesday, not.
at least Tuesday, my lord,
Tuesday also, yes, Tuesday.
but kindly Tuesday, my lord.
No, not
But
possible.
thereafter, my
Not
lord, 7
possible.
will be holiday, my lord.
Then
Well,
based on 8 then. 8 of. We don't have any alternative. What
My
to
lord,
do?
kindly,
Eight.
Tuesday, my lord. Tuesday, my lord.
8 on 8. 8.
Oblige, my lord.
May please your lordship. Lordship, I beg to mention a bail application for Tuesday, your lordship. Motion.
No Tuesday, but Thursday. It will be on 8.
Deeply obliged.
Item number
With liberty, lordship.
withdrawal.
With liberty, lordship. I'll finish, lord.
Liberty is always there. In a bail application, there is always liberty. Once rejected, the other one, it's always there. Is the petitioner is got arrested? No,
No.
not yet. Due to some other reasons. You are Mr.
M. Mondo, lordship.
M. Mondo. Dispose of on withdrawal. Okay, well, disposing on withdrawal, and don't you please, you are at liberty at any moment. You can
Sure.
file your petition. It's okay.
Oblige.
Ready, next item 1.
Yes.
Today, your lordship has fixed, because your lordship has fixed other matters also to hear whether that if court read and that whether that notice is required or not. But my case is different. Here, lordship, he was apprehended subsequently,
Okay.
not from his person. From his person, nothing was recovered. And that notices I have annexed at page 37, your lordship will find
37.
7. And 38 is the arrest memo.
You have a legible copy with you.
Yes, certified copy. I am.
It's completely illegible. One inspection memo also you have annexed.
Certified copy also same. lordship.
What is the name of the petitioner?
Raisul Haq.
Raisul Haq. Visible হয় মানে ইয়াতো একেই কথা আছে। Since when he is in custody?
He is in custody since 21/9/2024.
21,
2024.
24,
24.
24 or 22?
24.
24. POCSO, লিখি। Arrested on 21/9/2024. What is the stage of the case?
Charge sheet submitted, Lordship. As per my instruction, charges were not framed.
Not yet framed.
Not framed.
Charges submitted, charges not yet framed. Is there any absconder accused here? Have you annexed the charge sheet also here?
Yes, I have annexed the charge sheet, page 23, your Lordship will find.
Yes. No, just I want to see, is there any absconder accused?
Not mentioned.
Not mentioned.
And one of the accused, your Lordship granted bail on 23/4/2025. BA number 96625. The person from whom it was
BA,
recovered.
BA,
966/2025.
So as per you, the recovery was not from you.
Not from me. FIR was lodged on 11/7/2024. And he was arrested on 21/9/2024.
Near about 2 months.
Nearby.
After 2. Then we have CS লিখি দিব, CS submitted, charge not yet framed. Nothing has been recovered from the conscious position of the accused petition. He got arrested in connection with this case only on the basis of the statement of the co-accused. He drug আছে না to fancy করে দিব। আৰু ground of arrest to last. Ground of arrest. Yes.
Problem.
To whose satisfaction this one?
Special Judge Sribhumi.
Special judgment. Itu উলাই লব পাৰে BN 966.
Item 2,
Here in this case, Lordship, that these two petitioners were coming in a train, Lordship, and from that compartment, some contrabands were recovered. And subsequently, these petitioners were arrested, and it is alleged that they were in possession of those contrabands, Lordship. Now, here, Lordship, just what my learned friend on other day, what I have understood that he referred that Modhulima's judgment, Lordship. Just I am placing that, Lordship, may kindly see. But paragraph 10, he relied, Lordship, that those.
10?
Paragraph 10.
10.
10. That two requirements are there. Now, those after those requirements, Lordship may kindly see that it is mentioned that two requirements of clause 1 of Article 22 are meant to afford the earliest opportunity to the arrested person to remove any mistake, misapprehension, or misunderstanding in the minds of the arresting authority, and also to know exactly what the accusation against him is, so that he can exercise the sound right, namely of consulting a legal practitioner of his choice and to be defended by him. Clause 2 of Article 22 provides the next and most material safeguard that the arrested person must be produced before a magistrate within 24 hours of such arrest, so that an independent authority exercising judicial powers may without delay apply its mind to his case. The criminal procedure, now this part is important, Lordship. The criminal procedure code contains analogous provisions in section 60 and 340. So this is the initial criminal procedure code before 1973, Lordship. That code. But our constitution makers were anxious to make these safeguards an integral part of the fundamental rights. This is what Dr. B.R. Ambedkar said while moving for insertion of Article 15A, the numbered in the draft bill. So that Article 22 was numbered in draft bill as 15A. Regarding that, what he said, that is also quoted here, which corresponds to present Article 22. Article 15A merely lifts from the provisions of the Criminal Procedure Code two of the most fundamental principles which every civilized country follows as principles of international justice. It is quite true that these two provisions contained in clause 1 and clause 2 are already to be found in the criminal procedure, and thereby probably it might be said that we are really not making any very fundamental change, but we are, as I contend, making a fundamental change, because what we are doing by introduction of Article 15A is to put a limitation upon the authority both of Parliament as well as of the provincial legislature not to abrogate the two provisions because they are now introduced in our constitution itself. So they were well aware about those facts, that red-handed part. So second thing, Lordship, that Ramkishore Arora, which is referred by my learned friend, that also not in conflict with the judgments which we are referring, Lordship, because in that judgment also it is said that it has, the writings has to be, the communication has to be there within 24 hours. That paragraph 22 of that judgment, Lordship, may kindly see. In Vijay Madan Lal Chaudhary, that section 19 of PMLA was challenged.
You are on para 20?
22.
Yes. Yes.
In Vijay Madan Lal Chaudhary's, it has been categorically held that so long as the person has been informed about the grounds of his arrest, that is sufficient compliance of mandate of Article 22(1) of the Constitution. It is also observed that the arrested person, before being produced before the special court within 24 hours or for that purposes of remand, on each occasion, the court is free to look into the relevant records be made available by the authority about the involvement of the arrested person in the offense of money laundering. Therefore, in our opinion, the person arrested, if he is informed or made aware orally about the grounds of arrest at the time of his arrest. So this is the first part about his arrest, and is furnished a written communication about the grounds of arrest as soon as may be, that is as early as possible, within reasonably convenient and requisite time of 24 hours of his arrest, that would be sufficient compliance of so here what I'm saying, Lordship, that that at the time of arrest, if they orally inform and subsequently within 24 hours they give a written communication, that is the compliance of Article 22. That is what said Ramkishore Arora. So in my humble understanding and submission, Lordship, Ramkishore Arora is not in conflict with Bihan Kumar or Prabir Pukasta judgment, Lordship. And the judgment, which is other judgment of Allahabad High Court, it is relied on by my learned friend, that Om Prakash Dwivedi, Allahabad High Court bench. So I am not placing already my learned friend at place, just I am pointing out one thing. This judgment was decided on 11/4/1994. Prior to that, Bihan Kumar, Prabir Purkasta, Pankaj Bansal, those cases, Lordship. So that cannot be, the observations made therein cannot be applied now, Lordship, because now law has changed, the hierarchy we have to follow, Lordship. That whatever Supreme Court said, that we have to. So that also go. Now. Now here in the judgment, Lordship, may I kindly see paragraph 19, 9 and 17. So why I am referred that Madhulima case, that the Honorable Apex Court, while dealing with the issue, they were well about that red-handed part, but there is no observation. So whether High Court can interpret it now, for that purpose, I have given the citations now, Lordship. That paragraph 9 and 17. The
Yes.
The Learned Council had further submitted that once this court decided an issue by taking a particular decision, it cannot be said that the judgment delivered by this court is par incuriam or that this court has not considered all relevant factors while delivering the said judgment. So this was the main submissions, Lordship. Now, Lordship, may kindly see that paragraph 17, what is the finding of Honorable Apex Court? If the view taken by the High Court is accepted, in our opinion, there would be total chaos in this country because in that case, there would be no finality to any order passed by this court. When a higher court has rendered a particular decision, the said decision must be followed by a subordinate or lower court unless it is distinguished or overruled or set aside. The High Court considered several provisions which is, in our opinion, had not been considered or argued before this court when criminal appeal so-and-so was decided. If the litigants or lawyers are permitted to argue that something what was correct but was not argued earlier before the higher court, and on that ground, if the courts below are permitted to take a different view in a matter, possibly the entire law in relation to the precedents and ratio decidendi will have to be rewritten, and in our opinion, that cannot be done. And now, second aspect, Lordship, that my learned friend said that the Worley hit and run case is pending for judgment regarding that part, Lordship. Even if it is referred to larger events or the issues is pending, there is no bar in following the other precedents which are not set aside or stayed by a judicial pronouncement, Lordship. On that aspect, this paragraph 35. Paragraph 35. We are seeing before us judgments and orders by high courts not deciding cases on the ground that the leading judgment of this court on this subject is either referred to a larger bench or a review petition relating thereto is pending. We have also come across examples of high courts refusing deference to judgments of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position in law. We make it absolutely clear that the high courts will proceed to decide the matters on the basis of the law as it stands. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition as the case may be. It is also not open to High Court to refuse to follow a judgment by stating that it has been doubted by a later coordinate bench. And similar is another judgment, Lordship, small paragraph. Paragraph 4. Learned Counsel appearing for the petitioner has brought to our notice a coordinate bench decision of this court in the case of Union of India versus Sanjeev Chaturvedi, in which the point of law laid down in the earlier judgment passed by this court in the case of Alapan Bandyopadhyay has been referred to a larger bench. But so far as this bench is concerned, we do not think judicial propriety permits ignoring the ratio laid down by the coordinate bench in the case of Alapan Bandyopadhyay, as no decision has come as yet from the larger bench on the point of territorial jurisdiction of the High Court in a similar context. So that is my submission. And other judgments, Lordship, that even if your Lordship take up that Procedural POCSO judgment, have given that compilation, Lordship, and Procedural POCSO, your Lordship will find it starts from page 21. I am referring to page 49 of my compilation, paragraph 45 of the judgment.
Page 21.
Page 49 of my compilation.
Para 45.
445. We are of the firm opinion that once this court has interpreted the provisions of the statute in context the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land binding on all the courts in the country by virtue of Article 141 of the Constitution of India. And on other day, Lordship, my learned friend has said that all these judgments has followed Pankaj Bansal's case, Lordship. And even if your Lordship see the Pankaj Bansal's case, in that case also, that Madhu Limaye case was referred. But although it was in the knowledge of the Honorable Apex Court, that red-handed part is there, even if the Honorable Apex Court has not made any observation regarding that, whether there is scope for this Honorable Court to interfere on that part.
Yes.
I have nothing new to submit, madam. I have already submitted many times.
Yes,
madam.
we have got
Yes,
it.
only a point I like to point it out that my lord in Madhulima, my learned friend, perhaps my lord has to.
Yes,
Madhulima
submitted.
judgment, madam. Because my whole argument, I am not disputing my learned friend argument, my lord. That is correct, madam. That is a law. But the main thing is that, my lord, the fact of these cases are different. So there is no question of not following or the barring Interim or subside my lord these things, because the facts of the case here is different than those facts. And last day, my lord, I have relied on one judgment. We have 1976 3 SSC 334. I have given a copy of the same to the lordship. And again, like to read it, my lord. It is rule deducible from the application of law to the fact and circumstances of a case which constitute the ratio decedent, the facts, and not some conclusion based upon facts which may appear to be similar. The facts which may appear to be similar. Here the facts appear to be similar, but still it's different because here the persons are caught red-handed. In those cases, or these things, those are not minor. One additional or different fact can make a world of difference between conclusion in two cases. Even the same principle are applied in each case of similar things. Even in similar fact, a slight difference in facts make a whole lot of difference.
On that regard also, you have submitted one judgment.
That judgment itself I have.
Yes,
submitted. I'll also give a copy to him, my lord. My lord, then the question is, this court is taking a bail petition, my lord. The lordship has discretion. And lordship will see on the facts of the case. If it is different, to my submission, your lordship can differentiate.
Otherwise, regarding other argument, my lord, that is there, my lord. In fact, my submission is that, my lord, not only Pankaj Bansal, Praveen Purkayastha, or my lord Vihan Kumar, the law is there till our constitution is there. But the thing is that these situations, because constitution, because there is, if there is, my lord, a fundamental right, there is also reasonable restriction. Your lordship has to make a balance between public interest and the victim interest. So, my lord, here the law was discussed in a different proposition. But where, because what is the basics of Article 22(1)? To give a, so a person can know and he can take a basic manner,
Yes.
take a legal assist. Here he was already, because not only he is carrying contraband, prior, my lord, preparation was also there. Because just he will go and buy this contraband and he will carry, that is not, because these are organized crime. And otherwise, my lord, rest argument, my lord, I have
Yes,
already.
we have.
And one more submission, Lordship, that what my learned friend says that factually these are different cases. So Lordship may kindly see the Article 22 for a moment, Lordship.
Proceed.
Example, I have already shown to your Lordship that what was in the mind of the constitution makers, that the parliament cannot change it, so it was taken, given as a fundamental right. That Article 22, your Lordship will find 22(1). The starting word is no person. So here there is no distinction that a person who is arrested subsequently or at the spot, there is nothing. And even in fact, Lordship, they have brought this act in the year 1985 NDPS Act come into force. It also contains the same. After that Madhulima judgment, this act was enacted. So they were well aware about those facts that red-handed and subsequent arrest, those part are there. But they have not distinguished it. So if they have, the legislature has not distinguished it, can we say now at this stage that it will not affect, it will not be given, this benefit should not be given to this particular class of persons?
Why not Article 22(1), there is also no word that it should be supplied in writing. These are developed later because the law is dynamic, my lord.
If he argues that part, Lordship, then we have to again go back to Bihan
No,
Kumar and
yes,
the
my lord.
Purkayastha judgment,
Then
which
it's okay.
itself says.
Okay.
And my lord, one thing in Madhulima, my learned friend already pointed out, my lord. Here, because the proposition, rightly, my lord, he has shown it, that these are the things, my lord, based on those. That was my argument, my lord. I showed Madhulima before that House of Lords judgment, so that these propositions are still there and our Supreme Court also relied on them. But in Madhulima judgment itself, my lord, while in there are D actually, there is no paragraph marked, my lord. They have taken this view also and considered the view that it has not been contended on behalf of the state that circumstances were such that arrested person must have known general nature of the alleged offense for which they had been arrested by proposition number 3. That proposition in Christie versus another in Linsky, nor it has been suggested. So had the state the case was like that he was caught red-handed, obviously that would have been considered by this court. Here, while passing this judgment, Honorable Supreme Court has stated state didn't argue that point, didn't took that point also.
So my whole submission is basically, Lordship, that whether there is opportunity for the public official to argue before this honorable court that honorable apex court had not considered this aspect, so these judgments will not be cannot be followed. Whether that scope is there or not there, Lordship may kindly appreciate that aspect, because I have given those citations, and therefore, Lordship, I have also pointed out that at the time that Madhulima judgment, those aspects were in the judgment, mentioned in the judgment. But if the Honorable Apex Court, after recording some observations, had not given any direction, can this Honorable Court at this stage give some direction? And second aspect also already there, I have submitted another judgment, then whenever it is a judgment is referred to larger bench or for reference, that does not automatically absorb, automatically take away the benefit of the other judgments, Lordship. And still that Bihan Kumar, Pankaj Bansal, Prabir POCSO holds the appeal, so getting, considering those aspects, the petitioners may be released on bail, Lordship. Because there are no grounds of arrest in the arrest.
Madam, that point actually I have shown that not I was not relying on that point. That point I have shown that these questions are also is under consideration before the court. Obviously, this court can pass whatever judgment is reserved there. Regarding my that there are similar matters, my argument will be same. It will be repetition otherwise.
Yes, obviously.
Take unnecessary time.
And one more aspect is that coordinate bench is also yesterday given one judgment. I have, it is not uploaded. If it is uploaded to the today, Lordship, I will furnish to your Lordship. That in that case also possession was they are considering that aspect also relying on Prabir POCSO judgment, they were released, Lordship. So whether that particular sections of persons can be denied that benefit, that aspect Lordship may kindly see. Obliged.
I was saying if anybody has anything in one shot mind. Right.
No, there are. Don't you worry. There are.
No, that's why I'm saying.
Okay, to এটা অলপমান ওলাই ৰাখিবচোন just the side of it to do by equal side to do. Always compilation also can be compilation. Just to there. Check.
Item 3.
May it please your lordship. Lordship, this is a bail application. The facts of the case are very short and simple. On 30th March 2025, the police on a complaint goes to a LP school in Davagudi where they suspect that illegal cattle slaughtering is going on. From there on, they seize 120 kgs of beef and 2 suspected persons and other things are seized. And then they are arrested. 15 days later, your lordship, the petitioner, while traveling from West Bengal, who had purchased some beef for his own personal consumption, is apprehended and is annexed to this matter where he had no connection. If your lordship comes to the forwarding, page 13, your lordship. Just above grounds of arrest, your lordship. During the course of investigation, it is revealed that the below mentioned accused persons have also involved in this case. The FIR named accused persons, namely Muhammad Kalam and Joinal. So, your lordship, these are the 2 persons from whom on 30th March, the 120 kg is seized and they are arrested subsequently. Then now, and others are slaughter the cattle and below mentioned accused persons are sell beef meat in various places of the Gosaigaon area. On the basis of that information, above mentioned accused persons is apprehended with 20 kgs of beef at Kadamgudi area under the Gosaigaon PS when he was transporting the same. So while I am of the same district and of the same area, I am purchasing the same from West Bengal and carrying it to my home for my personal function. I am arrested and then I am annexed to this matter, which has no relation with. I am caught in a different area. I am not even aware of where the cattle slaughtering is happening. I have never associated with any of these persons, and I'm arrested. And my case, my name is annexed to this case, and I've already been in jail for 17 days without any reason, just because I was transporting it. I have not fled. I have not committed any other illegal activities in the matter, but it has been attached to me.
His involvement is after receiving the case, it will reflect it. Otherwise,
no, in this case, further detention may not be necessary, your lordship, because as
No,
you can
you
see,
were apprehended with how many kgs?
20 kgs, your lordship, for personal function, your lordship. And after 15 days, After
You
15
in
days,
20 kg you for your personal consumption.
for function, your lordship, at the family function and the village, your lordship, not just for myself, your lordship.
Where this slaughtering was going on?
This was going on in Davagudi LP school, your lordship. I am caught
LP
at,
school.
yes, as per the police report. I am caught at Kadamgudi, your lordship. It's some completely different area. And also I was coming from West Bengal. I was not even
So why you
associated
have
with-
come from West Bengal to purchase the beef in Assam?
No. I was bringing it from West Bengal, your lordship.
Bringing it from?
I
West
purchased
Bengal.
it.
No, you purchased the beef from where? Kadamguri.
No, from West Bengal, your lordship.
You purchased the beef in West Bengal
Yes, lord.
and were carrying to Assam.
To my hometown, your lordship. For personal consumption, your lordship.
And the slaughtering in the arrest difference, where is the slaughtering was going on?
In Davagudi, your lordship.
In Assam.
Yes, lordship. It's completely different area, your lordship.
That was in another lordship. After 15 days, he was caught with that 20 kg of beef lordship. That slaughtering was well done before prior to 15 days. But he was caught red-handed within the 20 kilos of beef when he was purchasing it from Bengal to Assam. His hometown is as per his statement, his hometown is in Assam.
Kadamgudi, yes. The 120 kgs involved is of a separate area, your lordship. This 20 kgs is not associated with this.
So you purchased 20 kgs in West Bengal.
Yes, that was for the function that was going on at my hometown. And that's what I was apprehended.
But why the beef meat is available in Assam also?
Yes, your
why
lordship,
you
but
went
it is,
to,
but it is, but the
West
slaughtering,
Bengal to purchase
but
your 20 kgs of meat?
but slaughtering and selling has been illegalized, your lordship. So I had to purchase it from there. I needed it from some family function. It was a urgency. So I purchased it from West Bengal, your lordship.
So this 20 kg with 20 kgs, he was arrested on?
On 15th April, your lordship.
And the slaughtering was on?
30th March, your lordship. And 120 kgs was seized on that day itself.
Yes, for some immediate. You are Mr.
A Mishra, your lordship.
We are on 3.
Yes, sir.
Your name is not here? Not reflected? No, your name is not reflected here, A. Mishra.
Oh, I've just registered, so it might not have come up.
Oh, Nawaz is behind there. Okay.
He has newly joined, my lord, so his name in the registration in the system is not there, my lord. He's newly joined the faculty.
When you, cleared your LLB?
2023, your lordship.
2023. Where from?
Any proposal?
Anil.
Yes.
What Mishra?
Aniket Mishra.
Oh, you are Aniket Mishra.
Yes, sir.
Okay. Good. Heard Mr. A. Mishra, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Full stop. Next part, it is submitted by Mr. Mishra, the learned counsel for the petitioner, that the present petitioner is no way connected in the alleged offense. And full stop. The alleged slaughtering was done. Alleged slaughtering was there in the alleged slaughtering was there was alleged slaughtering in the no. The alleged slaughtering was done on 30/03/2025. And the present petitioner got arrested with 20 kgs of beef meat on 15/4/2025, which he purchased from West Bengal and was carrying to his own house for some personal functions. He is no way connected in the alleged offense. However, as he was caught with 20 kgs of beef meat, he got arrested. And since when you were in custody?
Since 15th, your lordship.
15/4. Since 15/4/2025, he is in custody. The IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody, and hence further custodial detention, interrogation may not be required for the interest of the investigation. Next one, Mr. Goswami, the learned additional PP submitted in this regard, that it is a fact that the FIR was lost after coming to know about the alleged slaughtering, illegal slaughtering on 30/3/2025. And the present petitioner was arrested only on 15/4/2025 with 20 cases of meat. However, he submitted that CD may be required to know the actual fact of the case. Next one, considering the entire circumstances of this case, submission made by the London Council for both sides, I find that further custodial interrogation may not be required for the interest of the investigation. Accordingly, I find it proper to allow the accused to go on bail. So where it is pending?
Gosaigam, your lordship.
SDGM Gosaigam,
SDGM.
SDGM M Gosaigam, to dissatisfaction. Okay, that is.
Much obliged, your lordship.
Item 4.
No, please, Your Lordship. Though it is commercial quantity lordship, but no recovery lordship. After 1 week of the arrested the prime accused lordship, after 1 week I was arrested, no recovery from my position lordship. And the notices and that arrest memo has been annexed lordship, no ground of arrest.
You have annexed those notice?
About the certified copy.
In which page?
Page lordship will kindly see 24 and 25. Arrest memo and notice under 42nd.
24 and 25.
After 1 week I was arrested.
After 1 week.
Oh, 1 week lordship. The main recovery from other 2 person lordship in a bus 5/1/2025 and I was arrested on 11/1/2025 lordship, but no recovery.
Subsequently, any recovery from?
No. Forwarding report itself will say lordship. Lordship will kindly have a look at the forwarding report.
You know, this is a statement made by the
Maybe,
arrested
lordship.
accused. Maybe on the basis of the statement made by the arrested accused, he was preempted.
Similarly, no? So you are in custody since 11/1.
11.
Yes, is not yet charged.
No.
111 days.
Heard Mr. Esponi, this is the counsel for the petitioner, and also heard Mr. DP Goswami, the learned edition PP, appearing on behalf of state respondent. This is an application, section so and so, in connection with so and so. It is submitted by Mr. Munir that the present accused petitioner is innocent and he is no way connected in the alleged offence. No recovery was made from the present accused petitioner, though he got arrested in connection with this case on 11/1/2025, only on the basis of the statement made by the co-accused, which is Baki Hilekhidiva. And Goswami, same submission. Okay. To whose satisfaction this has to be?
Special just Difu lordship. And special just NDPS Difu RBL.
Not Sribhumi.
Lordship?
Not Sribhumi. Not from Sribhumi.
No, lordship, it's from Difu.
No, we are dealing with Sribhumi, na? That's why.
This is my first case of notice. Much obliged, Your Lord. Much obliged.
Special just default. And
Much
yes, and it is.
5.
Please, your lordship.
Yes.
It's a 483 application. And this matter already is a POCSO matter, your lordship.
POCSO?
The seated matter trial is already going on. It is an evidence stage.
POCSO with section 6 POCSO.
Yeah, six of POCSO, and the BNS sections are also there. Regarding rape is there. Under
Rape
12 years, under 12 years. So basically in this matter, my lord, since it is already in the evidence stage also, 5 of the witnesses have been deposed. So,
Including the victim?
the victim, yes. So we have already annexed 3 of the witnesses depositions. So now, basically now today notice may be.
We have to
Yes,
issue
yes,
notice.
yes, issue to the informant, and then the next given days.
Notice issue for review.
Call for a record.
Yes, we also call for the scan copy of the LCR along with the case diary. When it can be listed, the registry will do the needful. Response number 2 to apni jani na through jurisdiction police station ko video.
A short date or bit.
26/5.
Well, maybe the trial may conclude at that point of time because already 5 of the witnesses have deposed. There are 6 witnesses are there. So
On 19th, if it is possible,
19.
19,
Oh,
scan copy. of-
Scan copy,
yeah.
yes. And you text it by
Yes,
today or by
yes,
tomorrow?
Yes, public.
Item 6.
We have filed one additional. It আহিছে নেকি আমাৰ তাত?
I have extra copy, my lord.
Oh, we have not received the additional.
Extra copy, we have extra copy also.
Some you have received already?
He has not also received, I think also it is served to PP office or.
Call police.
Yes. It is regarding lordship non-compliance of this section 50 lords. We have mentioned in our petition lords. In this case, petitioner was arrested on 15/12/2023 and he is inside the jail for about 1 year, 4 months, 17 days lordship. Charge frame lordship and thereafter charge frame on lordship 10/4/2025. Till 6 witnesses cited. Till today, no witness examined lordship. In this case, lordship, I have annexed this.
Both you annexed only 50 CRPC notice, other one 50A or other,
That is not there in the record lordship.
not there.
Because in the forwarding, it is mentioned lordship. Will find in forwarding lordship. Forwarding.
Your petitioner's name is Gautam Kumar.
Yes, lordship. Forwarding. Forwarding at page 19, lordship. Page 19, lordship, at page 20 is the relevant portion, lordship. Only copy of notice under section 50 served without ground, lordship.
But apart from that, copy of the arrest memo, inspection memo, these are also there.
These are there, but 50A is not there, lordship. 50 is there, but without ground, and 50A is not there.
So just tell us, your petitioner was also caught red-handed?
It is alleged that lordship 2 persons were found by the GRPS police lordship at police station. 1 person thrown his bag towards this petitioner and fled away. Thereafter, this person caught lordship.
Is always in page 14. lordship.
Page? 14.
14.
So your submission may be correct, but otherwise it is from your conscious position as per allegation.
As per allegation.
Yes, you want to make any other submission because we are hearing the court red-handed separately and the other one is separately. And the last 2-3 days, we are hearing on that incident only. Same submission can be recorded or you want to submit anything else?
Lordship may, in the meantime, lordship may call for the record and my submission may, I should go by with the other council lordship. Whatever the judgment will be in the apex court, that will be the finality, I think, lordship.
That's what they are just, Mr. Ahmed also submitted that, and it is a fact also. There may be some cases to refer to the larger bench or there may be some reference also or whatever. But the decision cannot be stated, awaited till the decision of the other courts comes. But the question is that the larger bench, definitely it will affect our cases. And at present, we don't have anything before us. So we may call for the case diary otherwise. Scan record. Scan record.
It's from lordship, Kamrup Metro digit 2.
Kamrup Metro.
Lordship. Or lordship may fix with other matters, lordship.
Other matters, in fact, we are fixing because, but your matter, I don't know. What matters are you saying?
Lordship, the article, rights of the article 20 granted under by the constitution, madam, that cannot be set aside or like that, lordship.
Cannot be valid.
Cannot be waived, lordship. So that is why lordship.
So this is also same matter, but she is not most probably with the records and cases and all.
My agreement will be also same.
Yes.
Same.
No, her submission will be recorded in that manner or what? That's what I'm asking. Because we don't have anything. Scan copy is also not before us. She has already submitted 50 CRPC definitely. And admittedly grounds of arrest are not there. So if same submission can be kept, then we can keep it.
না আপনি সবার একে আর্গুমেন্টের
If you lordship hear me, then fix a date lordship to that regard with others lordship.
আমার ডেইলি
Some one of my matter is fixed on 8 lordship. Along with that, this matter will fix.
Yeah, on 8.
that can be done.
Okay. Okay,
So-
then on 8.
8
We are in the meantime, we calling for the case record.
lordship.
You want this one, I think we'll have otherwise.
We have this.
You have another copy?
Yes.
Okay. I see. Now they are sending it, so you can take it or what? Call for the scanned copy of the LCR along with the case diary. And list on 8. Okay, 8. The petitioner has also filed their additional affidavit, which is already received. Tag with the case record. Okay, got it.
Publish.
7.
May I please acknowledge?
Yes.
NDPS melod, commercial quantity melod.
Hmm.
The petitioners are behind the bar since 1 year and 7 months.
1 year, 7 months. Hmm.
Prosecution witness melod, there are 9, to my instruction, 2 have been cross-examined. 7.
9 witnesses to
Yes.
examine.
Madam, 7 left. Apple.
So basically, you are on the point of issue on long incarceration.
Ma'am.
Any other issues? And otherwise, your petitioner got arrested with caught red-handed.
One is the driver, the other one is the handyman. So they were carrying the goods. And so along with the tiles, those cartons were also available. So during the Naka checking, they were got. Records are called for.
And do one thing, then record maybe call for the record at present.
Madam,
And because hearing you, we cannot say that have you annexed the evidence of the witnesses?
no,
also
ma'am,
here?
no, ma'am,
Then obviously it will be required.
ma'am.
কেতিয়া কৰিব পাৰিব?
26 months.
20, 21.
20 or 21? 21 will do. Will in the meantime, there may be some more evidence also.
Ma'am.
21 fact we do. Call for the scan copy of the case record along with the case diary. Okay, 21 file by listing.
Much.
Item 8.
May I please your
Yes.
Dear Lordship, the petitioner was arrested on Lordship 10/2/2025, Lordship. Lordship, may kindly come to page number 28. The arrest memo, Lordship. Name of the petitioner is Dear Lordship, Kabil Hussain. Now Lordship may kindly come to page number 29. The inspection memo. And then Lordship may kindly come to page number 30. You are hereby informed that you are arrested in connection with this case. The sections are non-available. So Lordship, once again, Lordship, this is a case of non-furnishing of ground of arrest, Lordship. And so far as the FIR part is concerned, whether I was caught red-handed or not, Lordship. Your Lordship, the FIR was lodged on 8/2/2025. 8/2/2025. And Lordship, the petitioner was arrested on 10/2/2025. But Lordship, if we connect the FIR with the forwarding report, Lordship, then the clear picture is that the police were chasing the petitioner. He fled away. That is what it is written in the FIR. And in the process, he got
injury. He sustained injuries. And thereafter, he was admitted in a hospital. From the hospital, the petitioner was arrested. Recovery was from the scooty, which was abandoned by the petitioner as stated in the FIR, which was abandoned by the petitioner in a paddy field. Things were recovered from there. Petitioner was arrested in the hospital.
Page 18 FIR second para.
Yes, Lordship. And Lordship, assuming that it is a case of red-handed Lordship, then Lordship, my argument would be the same Lordship. And only addition would be Lordship. Paragraph number 43 Lordship, 46 Lordship of Professor's judgment Lordship. Paragraph number 46.
You
That-
just read it.
We are of the firm opinion that once the court has interpreted the provision of the statute in context to the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land, binding on all the courts in the country by virtue of Article 141 of the Constitution of India. Now, Lordship, Article 141 is very clear, Lordship, law declared by the Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all the courts within the territory of India. Now, Lordship, if we go to Article 22, Lordship, protection against arrest and detention in certain cases. Dear Lordship, the word Lordship which starts with no person. Article 22(1), it states as Lordship, no person who is arrested shall be detained. So there is no distinction, Lordship. And Lordship may kindly come to Article 22, subarticle 2, subclause 2, every person who is arrested, every person, Lordship, every person who is arrested and detained in custody shall be produced before the nearest magistrate. So, Lordship, these things are very clear, Lordship, and all the other things as Lordship already heard, Lordship. And apart from that, Lordship, coming to the present case, Lordship may kindly come to the FIR, Lordship, page number 18. Only the second paragraph, Lordship, I am reading.
Yes.
On arrival at nearby so-and-so hotel at 4:05 p.m., we put Naka checking at about so-and-so. Our source indicates that suspect Kabil Ahmed, who is the petitioner here, who was coming by a scooty without number plate towards us, that is Shibumi side from Badarpur side. But just after seeing the police, rider Kabil Hussain turned the scooty towards Puamara bypass road and fled towards it. In response, police staff immediately rushed towards him and apprehended him upon reaching a nearby paddy field situated just near the Puamara bypass bridge. Kabil Ahmed got down along with the scooty towards paddy field, and after going some distance into the paddy field, he failed to find a road and he left the scooty on the paddy field and then ran away on foot towards nearby area, that is so-and-so. So, Lordship, that part is there, Lordship, and subsequently, Lordship, he was arrested on 10. Assuming that, Lordship, this is a case of red-handed, Lordship, my other arguments will be same. Apart from that, Lordship, the petitioner was arrested on 10 at a hospital, in a hospital. So these are my submissions.
Yes, then we'll go by your submission, other part.
I'm not placing that judgment, Lordship.
Probable protest is with us.
And I'm having the original certificate copies. Arrest memo, etc.
It seems that you have submitted this
Yes,
certificate copy also.
Yes.
Okay, then, okay. Right. Team, don't make it these things as কি কৰিব এতিয়া dispose of ৰাখিব নে কি কৰিব এটাটো অৰ্ডাৰ কাৰণ বুলি থৈছো এইটো অৰ্ডাৰ বুলি থব নেকি একেলগে উলিয়াই দিম নেকি নে কি কৰিম because 2-3 more matters are going to hear. So maybe my Monday or Tuesday, we list the matters accordingly. Your order may not be today also. It may be reserved for next week.
Hi, Lord.
Order reserve বৈঠক, reserve বৈঠক.
Item 9.
May I please?
Yes.
In item number 9, Lordship, the petitioner was arrested on 15/9/2023.
Hmm.
As on date, Lordships, 1 year, 7 months, and 17 days.
15/9.
15/9/2023, my lord.
Yes.
Charge sheet was submitted on Lordship 30th of November 2023. 30/11/2023. Charges were framed on Lordship 4/3/2025.
4/3/25.
25.
Why waited for long?
Only 2 accused persons are there. Both were arrested. Both are behind the bar. But Lordship, as of now, no witnesses have been examined.
No, why charge frame on 4/3/25?
Lordship, either the court was on leave, and Lordship, there was one occasion when charges could not be framed, as because Lordship, the learned defense counsel has sought for an adjournment. One occasion was there, Lordship. So Lordship, I am seeking bail in this case, Lordship, on 2 grounds. First, Lordship may kindly come to page number 73. This is the arrest memo, Lordship. The name of the petitioner is there, Sanjay Suklavistya. Lordship may kindly come to page number 74, the inspection memo. The name of the petitioner is there. And then Lordship, the page number 75, notice of information under section 50. You are hereby informed that you are arrested in connection with the above referred case. The sections of the case are non-bailable, only dismiss. And Lordship, this is the first argument, Lordship, non-furnishing of the ground of arrest, and another is that, Lordship, prolonged incarceration. Here, Lordship, the petitioner is in custody since last 1 year, 7 months, and 17 days. And so far as the possession part is concerned, Lordship, whether I was caught red-handed or not, Lordship, here, Lordship, two persons. One is the petitioner and another person who has already arrested, Lordship. Both were traveling in a vehicle, Lordship, and the recovery was from the vehicle, backside of the vehicle. Another person was the driver, I was the occupant. And Lordship, if Lordship, we assume that this is also a case of caught red-handed, my argument would be same. But Lordship, the recovery was from the vehicle, Lordship.
That is very surprising. Charge sheet was filed on 30/11/2023. Two persons were there only. And charge sheet was also filed on 30/11/2023. However, the charge was framed on 4/3/25.
Even
Near about 2 years or 1.5 years,
1 year, 7 months. Even Lordship, I have annexed the entire order sheets, Lordship. Lordship may peruse the entire order sheets also, Lordship.
But 1 or 2 days, there may be a case for when defense counsel made
Only one.
paid for an adjournment, maybe there. But that doesn't mean that you will frame charge after 2 years.
Only 1 day, Lordship.
Okay, we'll pass here.
Yes, Lordship. The entire order sheet is there, but I have annexed. Highly offense.
Item 10.
Me, your lordship. My lord, regular bail, arrested on 3/12/24. My lord, nothing recovered from me. Page 25, the forwarding letter, serial number 10, your lordship will find. I was arrested on the basis of a statement of the co-accused. And my lord, page 33, 34 is the my lord arrest memo. And page 35 is the notice under 47 BNS.
Page 35.
page,
34 is the note, arrest memo.
arrest memo, page 34, 35 is the notice. And my lord, forwarding, nobody is absconded till date, everybody is arrested. And the forwarding letter, page 25. 25, serial number 10.
Your petitioner's name is Iqbal.
Kaim Hazari.
Hazari.
Case is not yet charge sheeted or
Not
yet.
not. My information goes, co-accused has been allowed to go on bail. Co-accused, though not named, my lord, was allowed to go on bail by this court. I have annexed that copy, my lord, page 78. And page 79 is the case number your lordship will find.
Your case is also Silchar PS case number 1149.
1149 to be.
2010. Order address is 78, page number 78. Order is same, more or less same order. Heard Mr. Pakindi, heard Mr. Your Kusami same submission will be heard Mr. PK Roy Chaudhary, Delaney Counsel for the petition. And also heard Mr. DP Kusami, Delaney additional people appearing on behalf of state respondent. This is an application section so and so in connection with so and so. It is submitted by Mr. Roy Chaudhary that the accused got arrested in connection with this case on 3/12/2024 and till 24 and till then, and since then he is in custody. There was no recovery from his conscious position, and the accused petitioner was arrested only on the basis of the statement made by the co-accused. This is a case of from which place?
Kachar.
Kachar Silchar. To the satisfaction of special judge Kachar Silchar.
Obliged.
Item 11.
May it please, your lordship, the regular bail application matter under 483 of the PNSS matter. Here he is in custody from 23/3, my lord. And page 17 is the FIR, my lord. And there was a, my lord, from the social media platform, my lord. Some information was received by the investigating agency, my lord. So one GD entry was made. That, my lord, the present accused petitioner before lordship, my lord, he is taking the name of a, my lord, political person and collecting money, my lord. And one paragraph says that he also took money in the name of investing in the stock market, my lord. And one specific allegation is that 7 lakh was taken by him, my lord. And all this, my lord, through WhatsApp chats and by that mobile number, it was collected. So here, my lord, not arrested on the spot, my lord, and on the basis of a, my lord, that social media, my lord, platform, my lord, chats, my lord. On that basis, this FIR was registered. So 22/3, this FIR was registered. And on 23/3, my lord, lordship page 19, this present accused before lordship, my lord, he was arrested. Now, my lord, from 23/3, my lord, it is around, my lord, custody for around 44 days, my lord. And he was taken into police custody. My lord, although they have complied with 47, my lord, but there is possible non-compliance of 48, my lord. So 47, lord would find that page 32, it has been complied, my lord. Page 32 and 33, my lord. So 47, I'm not on that, my lord. But lordship may kindly have a look at page 34, my lord. So 34, my lord. That is
It
section
is 48.
48, not compliance, my lord.
Anyway, see, Mr. Choudhury, the
My-
cases of a bit, whether these mobile handsets, etc., or whatever, I don't know, these were seized.
Possibly this is otherwise how they will get it, my lord. And already 40 is, my lord, these are 60-day offenses, my lord.
Okay, we try to get your case diary within short
My
period.
lord, my lord,
Uh,
with all respect, my lord, 48 non-compliant, there's so many from this honorable court also, my lord. Only on that count, my lord. Otherwise, my lord, I would not pay, my lord. Considering the length of detention, and my lord, not spot, my lord, and 48 non-compliance, there are some orders of this court also, my lord. So, not on the merits, my
Not in that lordship, his involvement is will form the case there, otherwise, but non-compliance of 48 and other things are. Maybe 47 is.
47 compliant, my lord, but 48 non-compliant, we were on V1, but this case came, my lord, he was arrested subsequent to Vihan, my lord. So that argument on spot and everything, my lord, prospective, retrospective, that is, we are not on that. Because this, he was arrested on 22/3, my lord, so that is subsequent to Vihan, my lord. And considering Vihan, my lord, this honorable court, should I place it, my lord, once?
what?
High court, our high court, my lord, in one case regarding 48, my lord. And Vihan law, should I place Vihan also? Not that Vihan last paragraph, lordship already seen, my lord. Here, lordship, para 10, my lord. Para 10, there's page 5, my lord, then lordship would see, my lord. It is also held that part, my lord.
Hmm.
Should I read it, my lord?
No.
It is also held that the aforesaid provision of the requirement of communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relatives, or such other persons of the accused as may be disclosed or nominated by the arrested person for the purpose of giving such
This is from
information.
I mean, most probably Bihan Kumar's
Yes,
second
yes.
part judgment.
Yes, yes, yes. That also we have. Should I place it, my lord?
No, no need, we have.
My lord.
Okay, we'll pass the order.
My lord. My lord, it will be Azizem Titabo John. It will be 42 days, my lord. 42 days. And SDGM Kitabo Johar, page 19 is the forwarding report, my lord. Oblige me. Much obliged.
May I please your lordship? It's a 482 application, lordship. Petitioner is a lady, lordship. She received a summon from DRI, lordship, to appear before the investigating officer, lordship. Accordingly, she collected the copy, lordship, in this case. She found that her son was arrested in this case, whose name reflected. It is, lordship will find the copy of this. Lordship, at page 10, it's chart. regarding the information of this case and all. Her son name is Sri Ali Ahmed Lordship. And information received by the DRI officers Lordship that from a Mahindra Scorpio car bearing registration number so and so, two persons would be carrying some contrabands in the vehicle, and subsequently Lordship the vehicle was intercepted on 16/12/2024. Then Lordship kindly turn to page what I found in this case, Lordship, kindly turn to page number 19, which is a part of the seizure list, Lordship. Page number 19 in column number 5. I think, Lordship, because of this reason, she has been summoned, Lordship. A copy of sale deed bearing serial number so and so, Lordship got it. Issued by City Car Bazaar, Doboka, passed by near Life Care Hospital, Ojai, Assam, indicating the car was sold to Nazma Begum by Wahidur Rahman. But in the column number 3, registration RC recovered, it is in the name of one Nilofar Yasmin. So because of that reason, Lordship, I have been summoned in this case. That is why, Lordship, I got a reasonable apprehension, Lordship. I am going to cooperate with the investigating authority, Lordship. My son is inside the jail, Lordship. I'm illiterate, a lady, housewife, Lordship. So, Lordship, to record
Just a second, but recovery is from your car.
from the car,
And your son
where
got
my
arrested.
son was boarded. That is the allegation, Lordship. And Lordship, only for a limited period, Lordship may protect me to record my statement and to produce any document if they seeking, Lordship, they are seeking any document, I can produce that if they are seeking, Lordship, anything, Lordship.
Yes.
For a limited period.
My lord, CD may be called for the witness, and meanwhile, we will file a objection regarding this case.
You're going to file objection.
Objection. A short date may be given.
In the meantime, I may be protected, Lordship.
Say file, otherwise I have understood your case. You have purchased the vehicle, the registration is not yet in your name, but your
I'm not aware whether my son purchased any vehicle or not, Lordship.
no,
See,
it is purchased in your name.
It is it's a deed.
The investigation is still going on.
Obviously, Lordship, it's a latest case, Lordship, new case, Lordship. One deed is there, Lordship. That one deed is there. That is even by Wahidur Rahman, not by the owner. Owner is, as per RC, is Nilofar Yasmin, Lordship. How this deed came and why did this is
See, there are two aspects. One is that car was sold to you as per this
Lordship,
forwarding and all.
Lordship.
That apart the contraband recovered from the seed car.
Lordship.
Number 3,
Lordship.
your son was there.
Lordship.
So there may be some suspicion on the mind
Yes,
of
yes,
so and so. That's
obviously.
why notice is issued.
Lordship.
So let us find the case record. I mean,
In
case
the
diary.
meantime, I may be just to appear before the investigating agency, Lordship. If anything will be there, Lordship may reject the petition, Lordship. For that period, Lordship, for a limit or 1 week or 14 days likely, Lordship, I'll appear before the investigating authority. Just to
where you have notice, where is the
notice, I have annexed at page number 27, Lordship. It was in 18 March, Lordship. Thereafter, I did not receive, but I am concerned about these things, Lordship.
So it was issued on 18 March and you were asked to appear on which date?
Any date, Lordship, if Lordship fixed.
No, 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 no. You were asked to appear.
There is no mention, Lordship.
Why?
2903. It is above, Lordship. Now, therefore. Now, right now, I did not receive any notice, but I'm concerned about this thing because my son is inside the jail. Some documents may be required from me, Lordship. That is why, Lordship, if anything is there. But as she stated before us, that she does not know anything about the vehicle, Lordship.
Heard MS SK Nargis, Learned Counsel for the petitioner, and also heard you, Miss Kakoti or what?
Yes, Chakraborty.
PS Chakraborty.
DRI.
Special PP DRI. Special PP DRI. And this is an application, section so and so in connection with so and so. Next, it is submitted by MS Nargis that the present petitioner is no way connected in the alleged offence. However, she received a notice from the investigating officer on to record her statement, which was issued by the authority on 18th of March 2025. She further submitted that from the forwarding report, it seems that one sale deed was executed in her favor, showing the purchase of one vehicle, which has already been seized by police, and her son also got arrested along with some contraband as alleged. Poster. Next paragraph. Ms. Nargis further submitted that she is no way connected in the alleged offense, and the car is also not registered in her name, which also reveals from the forwarding report, and the car is still under the name of the registration, and it's still under the registered owner of the said car is still one Nilofer.
Yasmin.
One Nilofer Yasmin. However, she has the apprehension of being arrested in connection with this case, as her son already got arrested, and one sale deed is also alleged to have been executed in her favor. She is ready and willing to appear before the investigating officer and to cooperate in the investigation and to produce any relevant documents which may be required in connection with this case, if she is provided with some interim protection. Next paragraph. MS Chakraborty, the learned special PP DRS submitted in this regard that they will file their written objection in that regard, and she also insisted to call for the case diary, which may reveal the actual fact of the case. Next paragraph. Considering this submission made by learned counsel for both sides, annexures filed along with the petition and other aspects of the matter, I find it fit case to extend the privilege of interim pre-arrest bail to the present petitioner till receipt of the case diary. In the meantime, the DRI also can file their written objection, if any. Provided some conditions will be there. If you need, then we can fix a date also so that she can appear. Further provide cooperative plus cooperative. The petitioner is accordingly directed to appear before the investigating officer on when you want to fix it.
But she is from Sri Bhumi Lordship, that is why Lordship.
10:30. 10/5/2023 at about when it can be 11:30 AM. Our CD call for CD call for 23/5/2020. 23/5 month for 10. Then 30. No, CD.
Holiday.
26.
There is not working days. Can it be on
Saturday?
30?
That will be the holiday for the department. So
There will be holiday for the department also.
yes, that may be 13 maybe.
1-3.
Yeah.
Okay. 11 for play 1-3 for doing. Okay, 1-3 at 11:30. Yes. 26/5 below. No? There are many matters, but they don't know how the says. This one I just go over by to supplementary.
Yes, here is bail application, your lordship. Case 9 is the FIR.
9.
9 years. Next one. 13, no? The petitioner is not named, but he's the driver of the vehicle from the metres. He was not aware about getting it right. And Atikul Islam, who had the vehicle of the petitioner from Tamara to Gauripur on the way, that he made an accident due to bad condition of the road and hit a auto. Then he fled out of here. And after that, the public and Bolgondong arrived there and they found the meat in the vehicle, and that's his.
130 kg of beef.
And Atikul Islam carried the beef. He is already arrested and he was already released on bail by the next session judge. In 26(3) by order. I had not any order. I am the driver, I have not claim protection, I had proper investigation.
So what purpose you are carrying
Not I am
130
not
kgs?
carrying. One Atikul Islam is carrying. I am not, I am the driver of the vehicle. He had the vehicle of the petitioner, one Fazol Ali and Atikul Islam. They had my vehicle, but I am not aware about that. vehicle.
So why you have fled him?
He made an
Because
accident.
He
with
made
the
an
auto.
accident with the auto, hit an auto on the road. The public gathered and he, out of fear of the public, returned his letter. And that owner of the vehicle, he was arrested, Atikul Islam, and subsequently released on bail, session hospital charges.
Not the owner, occupant.
No, Atikul Islam is the owner of the vehicle.
He is the owner.
Owner, yes. Atikul Islam and one Fazol Ali, they had my vehicle, yes.
One Atikul Islam and
And
Fazol Ali.
Fazol Ali also not there, not a
Of August 2024, no witness have been examined till date out of 7 witnesses.
Charge frame, when charge frame?
Charge frame is 28 August 2024. Then, Lordship, the 51,000 Yaba tablets were recovered from me. That means 5 kgs, 300 grams, without manufacturer details like batch number, expiry date, packaging, and source of counterfeits. The effects of the grounds of my case is that long incarceration, Lordship. And in case of long incarceration, I would like to proceed my argument with case number Sheikh Javed Iqbal. Para number 22, Lordship. Relevant part is highlighted, Lordship. When a trial gets prolonged, it is not open to the prosecution to oppose bail of the accused under trial on the ground that the charges are very serious. Bail cannot be denied only on the ground that the charges are very serious, though there is no end in sight for the trial of conclude. Then, Lordship, kindly come to the page number 23, page number 13.
Para number. Oh, page number.
Page number 23.
13, page number 13.
Para?
Part-
23.
Yeah, highlighted part. Over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. Then, Lordship, 23.1 para. If the state or any prosecution agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as enshrined in the under the Article 21 of the Constitution, then the state or any other prosecution agency should not oppose the plea for bail on the ground that the crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. Then we may hasten to add that the petitioner is still an accused, not a convict. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, howsoever stringent the penal law may be. Then the next page, Lordship, 14 page number, we are convinced that the manner in which the prosecution agency as well as the court have proceeded, the right of the accused to have a speedy trial could be said to have been infringed, thereby violating Article 21 of the Constitution. Lordship, then paragraph number 29, Lordship, page number 18, Lordship. Going back to K. Najib, this court thereafter proceeded to hold that Section 43D5 of UAPA Act does not oust the ability of the constitutional courts to grant bail on the grounds of welfare. Then long incarceration with the unlikelihood of the trial being completed in the near future is a good ground to grant bail. This court also distinguished Section 43 3D5 of the UPA Act from Section 37 of NDPS Act. Then, Lordship, paragraph number 32, Lordship. This court has time and again emphasized that right to life and personal liberty enshrined under Article 21 of the Constitution of India is overarching and sacrosanct. A constitutional court cannot be restrained from granting bail to an accused on account of restrictive statutory provisions in a penal statute if it finds that the right of the accused or under trial under Article 21 of the Constitution has been infringed. In that event, such statutory restrictions would not come in the way. Even in the case of interpretation of a penal statute, howsoever stringent it may be, a constitutional court has to lean in favor of the constitutionalism and the rule of law of which liberty is an intrinsic part. In this judgment,
How many witnesses were there inserted?
Eight witnesses, one, not a single witness is examined. 8.
And scan copy also not up to date, but which should be up to date.
Up to date, I think, up to date.
And he submitted the charge frame on 28/8/2024. 28/2 or 28/8?
28/8.
28/8.
24.
28/8. 2020.
Can copy. Don't know, 7/1/2025 is fixed for evidence. Thereafter, we have, do we have any?
7/1/25 last.
No, No witness examined. I am the advocate in the trial court also, Lordship.
This is your verbal submission. Do you have any other ways to submit?
No.
At least up to this can be made call for lordship. After that, lordship will decide.
Because here we have seen, as you have submitted that, we're saying 28, no?
28-8. More than 8 months.
Yes, 28 charge was framed. And then evidence was fixed on 22/10.
Even lordship, yeah, PP is not there, available in court number 5. No government PP is in the court number 5. So how can the next date witness will be examined? PP of court number 4 goes to the court number 5. Sometime if he is called.
It was of last order of 3/12/2024.
Yes.
And we are on the month of May now. So 5 months already left. So I don't know what will happen. As you have submitted, most probably may not be recorded as you have submitted, but without anything, how can we see? Record is there's nothing here. It's up to only 7/1/2025. Record is. When it was called for, in fact, why it is not up to date?
It's called for first.
Maybe February, on February it was called for.
February. No.
And up to the status report was called for 24/4/25, I think.
Yes.
24.
So 24/4 one order was there.
But record is not there.
That was not up to the status report is not received.
We can just call for the status basis from Kamruk Metro, no?
Yes.
But sorry to say that we don't have any dates. That is the main issue. And based on 18/19, thereabout, we don't have any dates.
No,
No, whatever, we don't have any dates.
I have not concluded my submission also. Please let me complete my argument.
Oh, okay then. Okay, you want to complete your argument. Okay.
Yes, Lordship.
Yes.
The next ground, Lordship, the no
No,
prior.
as you have confidently submitted that no witnesses examined, that's why we produced the case record.
Yes,
Because
Lordship, this is the
we don't know
first-
whether any
This
witnesses
is
have
the
been,
first
because we have
submission.
to note down it, whether any witness were examined or not. This is your formal submission only.
Yes,
That's what I'm saying.
Yes, Lordship.
Yes, what other part?
And the next my ground is no prior criminal record or antecedent alleged.
Mm.
The third ground is no videography, Lordship. The videography, non-availability of videography in spite of availability of time and resources raises serious doubt on the fairness of the investigation, Lordship.
No, videography may not be there, but inventory may be there. We don't know. If inventory is there, I don't know.
Inventory is there, but video.
Inventory is up subsequent. If it is certified, then it's okay.
This is mandatory provision.
Because in our state, we are seeing that they are not yet mandatory, whatever mandatory, I don't know, but in our state, we are seeing that this the videography is still awaited. It's not done. Anyway, next matter, videography, we do not want to hear about anything. And next, what is the ground? No
Ground-
criminal antecedents, it's okay then.
Then next ground is, Lordship, this is also no calibration certificate is there. No calibration certificate. The weighing scale was not calibrated, Lordship. And the last.
No, this will reveal in the entire things, inventory and all of what kind of scale they were used. How they were used, what is their used?
I have annexed inventory, that is not mentioned. Even the person who weighs
These are, but these are the
he's not made
metrics.
the
Exclusively, they maybe these are the materials, or these are has to be considered at the time of evidence or at the time of final hearing, not at the stage of
lordship. Lordship, the
We
last,
read some minimum compliance, may not be specific, but
yeah,
may not be total compliance, but part
Yes.
compliance will do
yes,
if it is there only.
yes. The lordship, the last but not the least ground, this is the grounds of arrest. Lordship.
Okay,
Again,
grounds of arrest.
yes, lordship, I have the certified copies of the copy.
Yes, it's okay. We have all
Grounds of arrest regarding the, I should not repeat the same, maybe handsome and the compare.
Where you have annexed the grounds of arrest, the notices you have annexed here,
Yes, sir. And I have not annexed I have certificate copy.
certificate copy. List. Your petitioner's name is
Habibur Rahman.
Habibur Rahman.
Yes, sir.
Now tell us recovery against recovery regarding recovery.
Recovery made from their position.
My position.
Your position.
1,400 year.
Actually, regarding corporate and debt lordship, I would like to submit one judgment. Supreme Court of India. The Sheila Shaji.
এটা আমি কি করবো একটু নাই সব জায়গায় সবের গ্রুপ আছে
In this case, that I am submitting. In this, judgment, also the Supreme Court has clear cut says that if I have the knowledge about the contraband, but the grounds of arrest has to be informed. This is a mandatory lordship. I may be aware or may not be aware, this is required. And the Supreme Court has said that in case of exigency arise, like the accident cases and hit and run, only hit and run cases, the Supreme Court has already put the question, if somebody, in that case, the grounds of arrest may not be required. But in case of NDPS cases, police got the prior information. As per the information, they get ready for the NACA checking and all. So their exigency does not arise, lordship. So in that case, lordship, I think that I have ample grounds for you to kindly consider my case or enlarge me to one day, lordship. The points of my grounds I have noted here. So if you lordship kindly permits, then I would like to give a copy of the points of my arguments.
We'll record the same submission from Mr. Goswami. কি কৰিব সব থৈ দিব নে ওলাই দিম order বুলি ৰাখি থৈছো let us see if it is completed then we can don't make it shows as a disposal if right now don't make it disposal right now we may pass the order then let us see at the end of the day because all of these things may create a problem দুটা আজি ৰিজাৰ্ভ কৰা হৈছে don't make it reserve to pass the order okay obliged
15.
May I please, Your Lordship? Up to the report was proper, my lord. No matter what happened, this is that case, my lord, where your lordship directed him to appear, my lord. This is that
Yes.
case where your lordship directed him to appear because he was enjoying anticipated bail from the session, special court chair. Then, my lord, because he was an employee of the farm, master was not at home, so he was taken into custody. He took the plea, I am the employee of this shop. I do not know anything. Then unlimited largest session judge granted him bail. So he was on bail, my lord, for the period from 3/7/23 to 11/1/24. He was on bail, my lord. And actually, he was thereafter, my lord, on 11/1/24, his bail was cancelled when charge sheet was filed against him. Then he approached before your lordship. Your lordship, I have annexed the order. Your lordship directed him to go appear and pray for regular bail. But he has been sent behind the bar since 8/1/2024, my lord. So, my lord, he is behind the bar. Trial has not yet.
Status report is there, Lordship. What I have seen, Lordship, it was dated 11/4/2025, where it is stated that firstly, it is true that firstly he was arrested, then he did not appear, and NBW was issued against him. Thereafter, on the strength of NBW, Lordship, this the present petitioner was arrested, Lordship. Moreover, Lordship, the other two persons are still absconding, Lordship. Again, the case is that, Lordship, for these two persons, the present petitioner and one is Nazrul Haq.
He is a master.
They were caught hold of, Lordship, this Yava tablets, 3,400 tablets, dear Lordship. Then, on asking them, they have stated that they have worked for one Abdul Kalam Laskar. And they led the police officers to that place, Lordship, and there they have found another 2.036 kgs of heroin and separately 0.598 grams of heroin, Lordship. And they led them to that place, Lordship. So the materials are definitely there, Lordship. And moreover, his conduct is, he is rearrested only after on the strength of NBW. He has not surrendered, Lordship.
No, no.
He has not come.
Yes, yes.
As per the status report, Lordship.
Yes, that's why he appeared before the honorable court and asked, pray for regular anticipated bail. By honorable court had directed he, yes, non-violent warrant was issued, madam. That's why he came over here for prayer bail.
But it is in the status report that on the strength of this NBWA, he was arrested.
Hey,
It was in the status report.
he appeared with an application and the order of your honorable court. And your lordship directed him to pray for regular bail, and the court below shall consider it according to law. That's the order. Absolutely correct. He may be sent behind the bar. Now, my lord, how long? My lord, main accused are absconding. I am in no way connected. Since I was a servant in the house, I have been taken into custody. It is not my house, nothing of their side. Mayor and domestic helper. And the main accused are still absconding. No trial started. Earlier, my lord, about 2 years I was behind the bar. Now again I am behind the bar. From 11/1/24, my lord. And moreover, my lord, this section 47/48 has not been followed, my lord. No arrest memo, nothing of that sort, no seizure list has been provided to me. On this count also, your lordship.
You got arrested on the strength of NBW only. Earlier part will not come now. Earlier, you were granted
I
bail.
never come because subsequent to my birth, that bail was cancelled. Learned court on the session
No,
special
no,
court
no. At the time of,
provided me anticipatory temporary bail from 430 under 439. Then, my lord, I was enjoying in the meantime charge sheet has been given. When charge sheet has been given, naturally learned court session court has special court has cancelled my bail. Then, my lord, out of fear, I have come before your lordship, whether I can get any protection. Your lordship directed me. Yes, I have complied.
you
Yes.
shown as an absconded there, no?
No. Not absconded.
Firstly, he was arrested, Lordship. Then he
No,
don't
yes,
appear
arrested.
before the court, Lordship, trial court.
Yes, I
Then
was arrested.
NBW was issued.
Second time NBW was issued because I did not comply with the order of the session court. That's why, because I thought that I'll get the bail here. But when your lordship order has been passed, I was taken into custody. Now, my lord, in the first initial arrest also, due procedure was not followed. 47, 48 was not followed. 50, that is 50A, 50 CRPC was not followed.
You could have
NDPS
taken
was not.
plea in that regard. Now that bail, that arrest is already been not there, not in existence. Now you are on the strength of NBW only. That is all.
My lord, I am no doubt I appreciate your view, but that I under NBW I was taken into custody. But your lordship, my initial arrest was NBW issued because of this that offense, my lord. Initially, my arrest was illegal.
We need an argument, then we not passed any order. Because at present, the status is a bit different, in fact.
My argument is that no trial is initiated.
Otherwise,
Principal accused are
by
absconding.
huge quantity of the Yuva tablets have been recovered.
My lord, I say that if there is.
You are a servant.
I admit everything is right, my lord. But I may be hard on the basis of trial. Now I am behind the bar. No trial is started. They're waiting for the main culprits. So this way, how many years I will be behind the bar?
Moreover, Lordship, one of the co-accused, who is Nazrul Haq, he was also arrested. He was again, Lordship, he is also on NBW was issued against him. The same will have to.
Then my case may be split up. My case may be split up. Something should be done because I am without trial. That is also violation of the fundamental rights. They cannot detain me years after year without trial.
Apart from material, I have objection regarding his conduct, Lordship.
My conduct is bad. That's why I was caught in the house of my master, madam. Who knows, madam, that the master is doing all these things, madam. Where I am illiterate person, all these things. That is the problem.
Okay, what any further argument, then we'll keep it.
But let my case be split up.
No, it is not on my part to, I cannot split up. You can make prayer before the learned trial court below. For splitting up of your case. How many accused persons are altogether in your case?
Three. Charge sheeted against 3.
Two are still absconding.
Oh, yes, absconding.
One is absconding from the, he has not cooperated in the search sheet also. It's in the.
He never appeared.
He never appeared. In the house where this.
That is my
was
master.
found.
That is my
Weapon
master.
was found. Two types of narcotics are found, Lordship. One is they were in their possession. Nazrul and Alkas, the present petitioner, these Yuba tablets are found. 3,400 tablets, Lordship. Again, then they led to this person, Abdul Kalam Laskar. And there, these things are found in his house. Though he was absconding, Lordship.
My lord, in a recent latest judgment of the apex court has said that even if there is a shown arrest, there also I have to be informed about 47, 48.
The conduct is also important, Lordship.
But your case is a bit different, in different footing. That's what I'm saying. It's not a case of shown arrest, not a case of
Yes,
arrest.
not a shown arrest.
It is not a case of.
On the strength of warrant of arrest, because my
only on the strength
bail
of
was
warrant.
cancelled.
That is why. Because generally in NPW, we won't be provided with any grounds of arrest.
Learned special judge, while considering my bail, my lord, for a temporary period, still the charge sheet. My lord, learned court below has perused the case diary. Thereafter, my bail period was considered. But when charge sheet has given, his hands are tied. There is a privacy, there is a case against you.
So can you pray for bail before the learned trial court below again?
That I have done as per your lordship direction.
No. Now you are in custody. That's what I'm saying. Earlier to NBW, on the strength of NBW, there was a
But if I
direction.
don't get anything, I have to go there again. That's naturally.
No, if you say that on the perusal of the case record and case diary, the learned trial court below had granted you bail earlier.
Situation has become such that I am without trial. That is my agony.
That is understood.
Then tell me trial immediately.
No, this kind of order immediately maybe there.
Situation now your
Immediately
lordship
cannot be there because
appreciate
one
that your
who
lordship have
who are
to appreciate that
absconding.
other
but still-
accused till they don't come, my lord, or they are not arrested. Should I suffer like that?
No, in that case, you make a prayer before the learned trial court below that your petition may be split up. That prayer has to be done before the learned trial court because we do not know what is the position of the case.
Yes.
The court
That's why your
may not
lordship
be in a position because in each case we require some reasonable time to get someone to declare someone absconder or to get the case record split up. So there are some requirements of time. So I don't know what is the position of the before the learned trial
If
court
your
below.
lordship peruse the record, my lord, I think scan copy also.
Yes, okay, we can peruse.
That is, I think, not up to date, my lord.
It
No, it is up to date.
is 11/4.
11.4 is more almost up to date, I think.
11/4/25.
11/4/20.
Then
It's up to date only.
update. Then I leave it to your lordship.
So as per you, there are materials.
Materials are definitely there because in his possession, lordship, this Yuba tablet has been found.
Alright.
He led this investigating officer to a person's house where another lordship narcotics has been found, that is heroin, lordship. That means he is also working for that person, lordship. He said that I work for that person. This is Abdul Kalam. And where heroins were found, definitely materials.
I am
are
not
there.
Abdul Kalam.
No,
Aklasuddin lordship.
No, in connivance, 29 is also
But-
there, lordship. Connivance, 29 is also there. Moreover, lordship, his conduct is also not good. One of his friend, lordship, co-accused, he is also, firstly, he was arrested. He was also NBW has been issued against him. He has not been arrested till now.
Contract will not come.
Contract
First
is
thing
not-
to be considered by your lordship, my lord, the house not belongs to me. House belongs to my master, under whom I am serving.
That is why 29 is there.
There, that's the 29. Her conspiracy, mere putting a section 20 and the conspiracy will not come. That's why, my lord, I want to
See,
face
these
the
are the things to be decided in the evidence itself. For a prima facie, we don't have anything.
My lord, his admission or confession, there is no confidence statement, mere statement before the police is, I know what is the value about
That
it.
is already there. That is already there. Heard Mr. S.C. Biswas, he learned counsel for the petition. And also heard Mr. K.K. Das, he learned additional PP appearing on behalf of state respondent. This is an application, section so and so, in connection with so and so. Present status report along with the scan copy has already been received. Let us see. Next part is submitted by Mr. Biswas that the present accused petitioner is innocent and he is no way connected in the LF offense. His only allegation against he was serving as a servant in the house of Abdul Kalam, and only on suspicion he was initially arrested in the connection with this case. However, during the your prior to charge sheet or after charge sheet, your bail prior to charge sheet.
Prior to charge sheet.
But considering the materials available in the case diary, the learned trial court below granted him the privilege of bail, and accordingly he was also enjoying the privilege of bail. But subsequently, when the charge sheet was filed, his bail was cancelled by the learned trial court below, and an NBW learned trial court below NBW was issued or what issued?
Cancellation also I did not appear, that's why it was issued.
Cancelled the bail and issued summon to the present accused petitioner. But as he failed to appear before the learned trial court below, NPW was issued against him. Post after getting the information about the issuance of NPWA, this accused petitioner approached this court with an application for 2 years bail, wherein where did the order he have annexed?
Your lordship's order was made on 1/8/24, madam.
No, you annexed here, page.
Next date I do not know, madam.
No, you have annexed the case record, that order. Order where you are directed to appear.
Oh, I'm sorry. But page 29. Relevant portion is mirrored at 31 minutes.
Page 29. Report with the page 20. It is appears bill. And by the order dated 19/6/2024 in AB number 1106 of 2024, this court directed the present petitioner to appear before the learned trial court below within 15 days from the date of order and to file an appropriate application for bail. But full stop. In person to that order, the accused petitioner already appeared before the learned special judge with an regular application for bail, but his prayer was rejected. And since is the order you have one is here? Your rejection order?
Well, annexure 6, madam.
32. Page number?
28.
28. That his prayer was rejected by the learned special judge by order dated 12/1/2024. So you are in custody since 12/1/24.
Yes. Yes.
12/1/24, and he was forwarded to judicial custody, and since then he is in a custody. Since then he is in custody. Poster. Mr. Biswas further submitted that the other two co-accused persons are already declared as an abscond are still absconding, and hence the trial could not be commenced till date, and though he is behind the bar for such a considerable period. Mr. Biswas further submitted that prior to filing of the charge sheet also, the present accused petitioner was behind the bar since more than
From
2 years.
3/7/23 to 11/1/24.
Huh?
3/7/23 to 11/1/24.
11/1/24 was in custody for 8, 9, 10. In custody for around 6 months, more than 6 months. That is from 3/7/2023 to 11/1/2024. But in spite of his long incarceration, the trial could not be commenced yet, and accordingly he submitted that he, being the permanent resident of his address locality, will regularly appear before the learned special judge and will on each and every date to be fixed by the court. If his bail prayer is considered against it. Next paragraph, Mr. Das, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present accused petitioner, and during the investigation of petitioner so far collected by the IO, and on the basis of which the charge sheet has been filed against the present petitioner. Mr. Das further submitted that from the record it is seen that how many Yaba tablets? The Yaba tablets, quantity of Yaba tablets? 3400. Around 3400 numbers of Yaba tablets were initially recovered from the possession of the present accused petitioner along with one. And thereafter, the present petitioner also led the police for recovery of heroin from the other co-accused, Abul Kalam. And thus he was very much aware about the contraband and which was kept in the house of one of the co-accused. And that apart, the Yaba tablet were directly recovered from his conscious position.
Moreover, Lordship, in his conduct also need to be
Yes,
there.
Mr.
On the
Das further
strength of his
submitted,
NBW.
Mr. Das further submitted that from the status report available in the case record, it is seen that he got arrested in connection with this case on the strength of NBW issued against him, and he did not appear before the special judge after filing of the charge sheet, though he was on bail. So his conduct is also to be considered, and in the same time, the other two co-accused persons are still absconding, and the probability of absconding of the present petitioner also cannot be denied at this stage. Next, Mr. Das further submitted that it's a case of commercial quantity and the rigor of section 37 will apply, which otherwise speaks that twin condition has to be satisfied. Mr. Das accordingly raised objection and submitted it is not a fit case to allow the accused to go on bail at this stage. Next, considering the entire circumstances of this case, the conduct of the accused petitioner, and the gravity of the offense, I do not find it a fit case to extend the privilege of bail to the present petitioner at this stage. However, the petitioner may approach the learned special judge with a prayer for splitting up of his case from the other co-accused persons as they are still absconding. With the above observation, this was disposed. Okay, this is.
80.
Yeah. Just a couple. This matters are. Yes. Anyway, whatever. Yes.
89 days, it came up before Lordship, 3 days back, Lordship was pleased to ask them, whether, any prayer has been made or not, for extension. It is a Unlawful Activities Prevention Act is also there, that's why,
But I have taken instruction when a prayer has been made, and they, in fact, the order will be passed.
Order will be passed today.
Today. Yesterday was holiday. Today is 89 days.
But today is 89 days, and what happened, initially that investigation, it started on 10/12/24 because FIR.
So yes, what to do then? 89 today is 89 days. So that's why we are called for whether there is any prayer been made by. As you have submitted, the prayer is made.
We'll fix it on Monday. Otherwise, tomorrow is Saturday. Otherwise, it could have.
Tomorrow is a working day there. Order may pass. Here we are holiday. So if the order is fixed for tomorrow.
Yeah, I am told, my lord, by the IO over phone. That's right now.
Then it will be on Monday.
But can I definitely what happened in this case, because the FIR and the first forwarding, those persons they were directly involved, as per those FIR and forwarding, and the investigation it started on 10/12/24. All those persons, who are dreaded, as per the FIR and the forwarding report, they are dreaded terrorists, some from Bangladesh and all, So, those persons already allowed to go on bail. No, prayer for extension. Now, possibly we have come before. That was passed by a learned session judge, and some orders also we have got,
No, whatever we are saying that as the status report was called for, and Mr. Kaushik has submitted that there was a prayer. That's what we are asking because you are on about to 89, 90 days. So at best we can fix it on Monday. Otherwise we don't have any out. Your prayer may be considered, may not be also. That's what I'm saying.
If not considered, he is eligible for.
Yeah, obviously in that case. Your petition is still before us, so we will in that case we'll get a default bail.
I'm not, what I mean, definitely on Monday, I have no, here, all those granted, and my lord, if there is some, even if it is extended also, possibly is entitled to bail, because my lord, all granted, my lord, and nothing against him. So far, those forwarding reports are concerned, my lord, that I had.
In that case, that's what I'm saying. In
Monday,
that case, suppose
Yes, yes,
bail, if
On
it is
Monday.
extended also,
Monday.
extended doesn't mean that you are not
Yes,
entitled
yes,
for
yes,
bail.
yes,
That is
yes,
there.
yes.
Because there may be some prayer for extension.
Huh?
And as you have submitted the main accused
Yes,
person or
yes.
the main culprits had already been
Yes,
granted
yes.
bail. So may not be there, or extension may not be there also.
Yes,
I
yes.
don't know.
Because what I meant to say, well, we came before this high court. This person will be 90 days will be over.
Mm.
So they immediately went possibly for extension. Because normally what happened, my lord, you have to file that, you have to, the reason is to detain those normally, my lord, those persons who are directly involved. So they are allowed to go on bail, my lord. Now they wake up from their slumber, my lord, that, oh, he will also granted bail. Let us file it. That is only, my lord.
Maybe,
My lord.
Yes, then we fix it on Monday.
Monday.
Somehow fix it on Monday.
Monday.
On Monday today also many matters will be left over, I think, because at 2 we have fixed 3 matters that has to be heard. So other matters may I don't know. Anyway, your matters is there, so we are listing it on Monday. Somehow Monday. Pardon? CDB written. CDB written till instead of listing.
My lord, can I make one prayer, my lord? My lord,
Yes.
regarding item number 31, my lord.
Monday 5. Yes, what can?
31, my lord.
Mm.
Can it be on, my lord, on 9th, my lord? 31, item 31, my lord.
No. We don't have any space on 9, 10,
Kindly, my
11.
lord. My lord, kindly, my lord.
We don't have any space.
In jail, my lord.
Yes, in jail, but we don't have
No, that,
jail.
my lord, diary is possibly here, but that report did not came, my lord. And it is only 7 years punishment, my lord.
We
Kindly,
don't
my
have
lord.
any space. Monday.
One case, my lord.
No, one case too. Today will be a lot more, many
No, I
cases will be
understand.
adjourned today.
If possible, my lord.
This morning we are hearing only that issue only.
I'm not seeking earlier on 9, 2 days, no, every day. After on 9, if possible, man.
Now see, fixed matters are there. We are fixing the fixed matters nowadays, all the fixed matters.
Kindly, my lord, I have not have paid, my lord. Inside, my lord, and around. He is inside, my lord, kindly, and no 41A also. I'm not on that now, my lord. Kindly on 9, my lord.
31 to 9/5 corridor. Mayor and Bishop.
Much more, highly of this, highly of.
আৰু এটা মাতক নেকি নেকি এটাও দিল এটাও লৈ লওক মানে দেৰি হৈ যাব
Much more.
জাষ্ট
19.
May it please your lordship. Lordship, this is a regular bail application, lordship, 239 days in jail custody, lordship. Here, FIR lordship will find on page 18, lordship. And I have annexed the 164 statement also, that is on page 25, lordship. In 164 statement, she
No,
stated
no.
she is.
Who is appearing here? Who is representing the respondent number 2?
Last occasion, there is a direction, lordship, to confirm whether the service was completed.
I tried to contact the IO, it seems that they are busy in today's election, that was the issue.
So to cut short the delay and all everything, so can we appoint amicus? Heard Mr. B. Chaudhary, the learned counsel for the petitioner. And also heard Mr. R. Kaushik, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Kaushik that though he tried to take instructions regarding the service of notice on respondent number 2, the police officer did not respond as they are busy with the election duty. Considering this submission of Mr. Kaushik, and this court is of opinion that amicus may be appointed to represent the respondent number 2. Further waiting for the without not awaiting for the further not awaiting for the service of the respondent number 2. Accordingly, now to the option given. And Mahajan. Okay. If you are not in the list also. Yes. Accordingly, Mr. N. Mahajan, we are appointing. Mr. N. Mahajan is hereby appointed as an amicus to respond in respondent number 2. Resti will do the needful. And copy will be provided by the Resti or by the petitioner. Resti will do the needful industry. List accordingly When your is a charge sheeted case, I think.
Yes, Lordship, charge sheeted case, Lordship. So for the Lordship statement number 164 statement, she stated, Lordship, she have
No, these are okay, but we don't have space. Main issue is that only.
Short date.
1920. No, we don't have. That's what. 1920 ka puro paribo ni. 23. At best 23. Okay. 23 will do.
Can it be on 16, Lordship? This is-
16. Somehow did your car parade. Okay, 16 to no, not possible. I think 16. You paribo.
After 16, 17, and 19, next Monday.
16 Saturday, Sunday, then 19. Okay, the 19th.
Hello.
Name may be shown in the call.
Pardon?
My name
Yes, yes. DST is also hereby directed to show the name of Mr. Mahajan in the cause list on the
Right.
next date. Yes. Him. দুটা আছে দুটা কিমান 32 and 33. কি? 32 and 33 আছে এই দুটো বাকি এইবিলাক ৰখি যাব so not just ৰখি যাব এইটো ল'ব লাগিব দুটা
39 to 2 p.m.
2 p.m. এইটো আগতে লৈ because it may not take much time এই দুটা টাইম ল'ব Mr. Dotto আহিছিলে ইয়াতে তাতে PP Dotto. We have two matters that here have three matters. So some of the matters may get adjourned today. There are some matters where Mr. Mannan was there, but that may be adjourned also, I don't know. But similar footing he has already appeared
Yes,
in other two matters. So these matters may got adjourned.
Perhaps, my lord, that day he already, in one case I saw, my lord, not related to this matter, but he already pointed out some
Yes, they were the NCB was there.
NCB.
Yes, we have already noted down.
Yes.
Okay. Yes, 39 first.
Except to item 39 for orders.
But I have instructions to appear for respondent number 1.
Okay.
I need some time to file my problem.
Find your power also and this you're going to file any objection on that item?
Yes.
You're
Let us-
filing.
Yes, I got the copy today only.
Yes.
Your lordship may give a short accommodation because matter is.
The person is, my lord, I'm told he is at posted at Dibrugarh, my lord. So that is why.
Presently.
Presently.
Your lordship may.
Then yes, Mr. Das, when within one period you can.
Yeah, my lord. Lordship may fix it after 2 weeks further. In the meantime, let us go through this petition also.
Yes, Mr. Kaur, 2 weeks will do.
Then your lordship may kindly fix it on 15th of.
The 15th, my lord.
16th.
16th
of May.
16th.
May.
I'm only appearing for 1 month.
Yes, sir. Others also 16, your lordship can deem to be served after 30 days because we have already taken dusty service. Or we
And
can also.
only in that dusty, in regards to dusty, have you filed any affidavit?
Yes. And even otherwise, after 30 days, your lordship can presume to be have been served. We have taken step also. Or during this period, I can also publish a newspaper advertisement if your lordship's ready. And everyone has signed, meaning the dusty, everyone has acknowledged receipt.
So
It
there
has
are
been
as
flagged
many
in the
as
file.
how many? How many?
It has been flagged in the
Respondents
file.
are there?
1 to 31, my lord.
1 to 31.
Please to leave. And the signatures your lordship will find at page 133.
133.
And we have taken the usual service by through the court registrars. But Riddhi is awaited, but after 30 days, your lordship can
deemed.
So why you are appealing for one only, the association or whatever, I don't know, but
One, because this association, one was the plaintiff before the trial court.
And his services, I think, going to retire very soon, next month. 6 months.
no. In the earlier occasion, most
Yes, I had appeared for one only. ma'am.
On the
This-
last?
Yes,
Ah.
this one was the plaintiff before the trial court, madam.
Hmm.
Now, an injunction order was passed in favor of the one. Now, they have challenged it in appeal, it was not interfered with, then against that appellate order, they have approved this honorable court.
Other respondents are also part of the new committee also, my lord. Only if he is appearing for one, but it's, and after 30 days, your lordship can acknowledge that it has been deemed to have been served, and we have given the justice service along with the affidavit of the receipt. But if your
So
lordship is,
number one is the Assam PWD Service Association.
yes. And one
So
of two are-
these two, 3, 4, 5 onwards, they are the,
Party to this committee.
they are also,
all are party to this committee, my lord.
all are party to this committee.
2 to 30. But
Not
even
this
if,
committee, ma'am, the
but even if
committee-
your lordship desires, we have no objection, because this is ultimately an association of the persons working in PWD. If you don't have the association, now it is headless. If you don't have the association, then it is very difficult to negotiate with the government or to sit with the government to formulate policies for the development of this people. So, my lord, I can also get a notice published in the newspaper within a week from today by.
No, if Dusty is dead, then
Um,
it's
yeah.
Let us wait for service, my lord. What is?
No, no,
the-
Dusty, we have done it.
Yes,
We have
that is
filed
why,
the
if Dusty has been done, my lord, lordship is fixing after 16. If 30 days, my lord, expires, lordship may deem it, my lord, then the question
Then,
of publication.
your lordship may fix it on 16th of May. He has.
16th,
16th.
Yes, sir.
16.
We are looking.
39. Mr. B. Deco. The learned senior advocate assisted by you, Mr. J. Singh. Counsel for the applicant, and also heard Mr. A. Das. The appearing on behalf of respondent number one. However, Mr. Das submitted that he has filed his Bakarat number today and needs.
No, I need some time, my lord.
Yes, you
It
need
is in
some time
transit.
to file the written objection.
And it should be
Further,
filed
it is-
before 19, so that we can also go to it, not on the last day on 19, my friend will file. But before 16, at least file his objection, madam.
Further, it is submitted by Mr. Kwon, the learned senior advocate, that the notice on to the other respondents, that is up from 2 to 31, is also served and to Dusty Mode, and they have already filed their affidavit to that regard, wherein the signatures of all the respondents are also seems to be all the respondents made their signature against the said notice. However, the service may be abated till next date of listing for the other respondents, and also enabling the respondent number one to file his written objection. List accordingly on 6th, you want to?
16.
Whose the direction should be in there only?
No, your lordship will
16.
make it clear that at least my, the respondent number one will file their.
Fixing it on
16.
16 for awaiting service report on the other respondents.
Normally, your lordship.
Until and unless service is complete, my lord.
Service is complete. We have filed the Dusty
So,
service.
That order should fall from the court, my lord.
Your lordship.
Lordship is fixing on 16 for awaiting service, that whether they will appear or not. Now, on 16th, your lordship will, my lord, whatever may be, they expire deemed service or whatever, then the proceeding will
No,
start,
no,
my
no,
lord.
my lord,
No,
he
no, by
wants
that
to
time we
delay
are
the
not going to
proceedings.
file the objection.
Well, we may not find, my lord. First of all, we have only got it today, my lord. Let us go through it.
Then matter will be delayed, I think, in that
They
way.
want to delay the matter. Your lordship
No,
will.
no, I'm not on that.
Not delivered.
No, no,
If my land
you're-
friend is so.
no, no,
is
you're-
such an-
please,
I'm-
please.
No, I'm ready to argue it today only, my lord. If my learned friend says that I am trying to delay the matter, I'm ready to argue it today.
No, no, it's not a convenience of my friend, or your lordship has expressed that
No,
the
no,
other
it is such
respondent.
a hurry that. on
Yes, we are in a hurry.
So to do it today, why not? Why
No,
not today?
you are not holding the brief for the other respondent, my friend. You will address the court, not
No,
me.
yes, I'm addressing the court only.
Please,
Lordship
don't
has said
point fingers at me.
16, on 16, your lordship.
I'm
has
not
been
used to this.
For, awaiting service report.
Without
If it
Wukalat
is on-
Nama, my lord, what is this address of the court?
What
What practice he is following, my lord, without a Wukalat Nama? How he is holding the brief of the respondent number?
Instructions to APR, my lord.
No, no, that is not the procedure of the High
And
Court.
if that means that
We are stranger
what
to
type
all
of
this.
petition is this, my lord?
Tomorrow anybody can
What type
come
of
and
petition is
appear.
this? Is this a petition? Lordship will see under what provisions of law this petition has been filed.
My lord, he is not filed a Ukalatnama. We are
Let it-
courteous
let-
enough.
my lord,
Your
let-
lordship has
let it
gracious
be
enough
fixed
to
on
give you an
16.
audience. He doesn't have an
Let
audience
it
without.
be
He
fixed
is
on
not a
16.
designated senior to come
In
and
the meantime, my lord,
address this
in
court
the
without a
meantime, file a
Ukalatama.
Wakalatnama.
Should I
And
teach
if
him the
required-
elementary
No,
principles?
no, we
of-
are just
Require-
fixing it. We are awaiting service till
That even
65
if
and
required,
that
we
apart.
file an
No, no.
objection, and if
My
not
other part is that apart, you have already appeared for the response number one.
One.
You are going to
Yes.
file the Wakalatnama. We have just it is that if there is any written objection, you can file on or before the 16th. That will be the order. So in that case, if you file your written objection, you may serve the copy on or before the next date of decision. That is the order.
Served, my lord. Otherwise, the registry will not accept, my lord.
Okay, then 16th, and then before 16th of the file. Going to file. So we are fixing on 16th. If everything is okay, we may hear the matter may be heard also. I'll say.
That's what I was praying for.
I also am saying that if later we have only got it today, let me go through it, my lord. If required, we'll file objection.
But
Otherwise,
our
we'll do the hearing.
graciousness,
Submission we also do. If
but
you
our
submit already.
graciousness will not be considered as a weakness, my lord. We are gracious enough to allow him to address your lordship without a Ukalatama. This is not the practice followed, my lord.
My lord,
Now he has the instruction.
yes,
that-
my lord, I have the instructions, my lord.
Uh,
here. Yes.
Forget about instruction. We are
And
obliged.
my lord, what type of petitions are these types of petitions are
My
entered?
lord, again, he is addressing on the merit. He let him come prepared on 16.
Yes.
He can argue on that day with the proper Ukalatama.
Okay.
Except 2, item 32.
May it please, Judge.
Yes.
Hopefully the case diary is coming. It's a voluminous one.
I don't know whether Mr. Doctor has gone through the entire case.
Only one thing, my lord, to. He has already flagged Marty. As
Yes.
regards the merits of the matter,
So your submission will be more or less same in both 32 and 33.
32. So I have prepared a common synopsis in both the case, which will cover the factual side as well as the legal side. And I will just complete my short since I am submitting this. Oh, my lord, I have given my copy. I'm so sorry. But we need more copy to do. I'm extremely sorry. Photocopy. And the compilation of the judgments also, my lord, which I have referred to and relied upon, I am handing it over in a different, this is the compilation. For both the bail applications, I have made a common synopsis.
Yes.
Basically, to be very brief.
Yes.
Basically, to be very brief, I have gone through the facts. I go back to my school days. Very often a question came, elucidate for that 5 marks. One Assam, I belong to I studied in vernacular school. Rozai bhal bule jak, hati ghura nalage tak. Rozai bea bule jak, puta hal nalage tak. So that was how we were asked to explain. So when I was going through the facts, the factual matrix in short I have already given. Basically, there was a turning point around 2017 when both these children, both these young men, not children, they left their lucrative jobs in USA and Infosys in Bangalore. And then in order to attend their ailing parents, mother suffering from cancer and the father for a heart ailment with a stent. That was the greatest mistake of their life. One stood fifth or in all of some, what is called civil service examination. One stood 10th. Now it harder got misfortune that the one who was the next case, he fell in love with another colleague of him in the same district in Sipaja. I will not name anyone now. That's not proper. Now, that was deprecated because it is interrelated. And that sequence of events leads to an order from the CM, the highest authority, for an inquiry. immediately thereafter, a CM vigilance case was registered. And immediately thereafter, one of the brother was suspended. Number one ground is he is also working on honorarium basis for Infosys as an analyst. So they have said you are getting double salary. So you are suspended. That was intervening period in February, March.
Which number? 32 or 33?
27.
No.
27,
Item
92.
number 32 or 33. Whose
32,
case?
32.
32.
So the suspension order is also enclosed.
Yes.
The matter did not stop there. On 4th of April,
Yes.
both the brothers were picked up and were arrested in connection with two different Chief Minister's vigilance case. One is 8, one is 9. And Chief Minister's vigilance case necessarily has to be under the Prevention of Corruption Act. And what has drawn my notice from the records in item number 32, that when the forwarding report discloses many things, they have the SEC period was from 19, and they have their panel chartered accountants. They do not take into account the background check. One was in USA, one was in Infosys. They're starting from 2019 and found that in respect of 32, 20 lakhs cash investment. So that presumption is that this must be a bribe money. And since the case diary is here, probably let it go before your lordship. So I will make one more statement. You can
No, you can submit first. Then
if
we
the
will-
whole case. What is touching my heart as a senior counsel, in the other 33 case, item number 33, the wife of item number 33 was also called for investigation. And a statement was recorded by the IO that she is ready to divorce the 32. That is a big success for the investigation in a prevention of corruption case. And in both the cases, I have found it is their statement in the forwarding. I have in my, your lordship will definitely, forwarding report, they have says that because it is not a 13(1)A case, 13(1)B case. They have said we have seized the bank accounts. When the bank accounts are seized, UPI payment, bank transactions, and being a 13B case, not 13(1)A case, nothing more is required. Therefore, if a lordship records from the records, it will say they ask for 3 days police remand from 5th to 8th. On 8th, when they were on 5th, we moved a bail application. On 5th, we moved a bail application. The remanding magistrate, he fixes the bail application on 10th of April. In spite of his ordering for that after 3 days, the production police remand will be over. On 8th, that is 5th, 6th, 7th, 8th, when both the brothers were produced, remanding magistrate for jail custody. On 10th, when my bail application was taken up, saying that you are already in jail custody, bail is rejected. And jail custody is up to 22/4/2025. 2025. 2025. on 22/4/2025, with a one-liner, without reference to the how, what is the progress, if you have any, because they did not want them, police remand. One-liner says that your jail custody is enlarged, increased up to 6th of May. Your Lordship is very much aware of that Satinder Patil case. That there is a direction to the investigating agency and also the remanding magistrates that what is to be taken note of. And also in this case, when the approval was given to inquire into, in between that intervening period from February to March, because April they arrested me, I did not receive any notice from either under 41 or 41A. I will not take your Lordship's valuable time because an n number of occasions your Lordship has gone through what is Anish Kumar and all. That it will be wasting of your Lordship's valuable time. Now, regarding my legal submissions, whatever I have made, that starts at, my Lord, paragraph 13 of my synopsis of my factual backgrounds is up to
Synopsis.
Synopsis of art. Because I thought it will be much more convenient for Lordship if I give it in writing. Because sometimes the age also runs against me, so I thought better to dictate and cut short my whole thing without any hesitation at the bar. So paragraph 13 is the other submissions. And as regards the judge, with the citation, my submissions, I have referred the judgments also. Only 10 days back, our High Court, before going, Satinder Pal also I have annexed, has given a beautiful judgment. I call it a bond-free judgment. That your Lordship will get it at page 199 of the compilation I have. The beautiful poem it has started. But before I go into that judgment, my Lord, this is a judgment where division bench of our High Court has dealt with the interplay between Article 21 and a very stringent provisions are there, your Lordship knows, in preventive detention. Then let me say 199, my Lord. Beautiful poem. It is authored by Honorable Justice Devasis Borua. It begins with, I will rely on paragraph 1 and 2. It's a beautiful exposition of an interplay between 21 and a law like preventive detention. May I read, my Lord, only one first paragraph? It's a beautiful, starts with a poem.
Yes.
Born free as the wind blows, as free as the grass grows. Born free and beauty surrounds you, the world still surrounds you. Each time you look at a star, stay free, with no walls to hide you. You are as free as roving tide. So there is no need to hide. Born free and life is worth living. It is only worth living if you are born free. On next paragraph is, he says, the above is a verse from a song, which was introduced in the cinematographic version of Joy and Adamson's memorable classic Born Free, which aptly described the concept of personal liberty and individual freedom. The said personal liberty and individual freedom can be curtailed by preventive detention laws, which could be used to consign an individual to the confines of jail without any trial on the basis of satisfaction arrived at by the detaining authority on the basis of the material placed before him. Now, court goes on. At the end, the Honorable Division Bench says that interplay 21 will prevail. If your investigation is over, you are not even wanting him for any police custody. Keeping him jail custody cannot be a sadistic pleasure of a person. So, as regards the other Supreme Court judgment, which most probably investigating agency is not aware of till now, this is a very recent judgment of our High Court. It has followed the Satinder Pal case. Satendra Pal's case is at page 63. But I call this judgment, normally we remember the judgment by name, but our High Court decision, I have also told many that I call it a bond-free judgment. Page 63.
Yes.
Page 63, front page itself, there is a direction to the investigating agencies as well as the remanding magistrates that mere mechanical exercise of power to that someone should be jailed after this. It should not be like this. Even the government was also directed to make a scheme. And your Lordship, other day, most probably Lordship has gone through already the speech of Justice Oka. That because the jail, this bail jurisprudence has initially started its change development from 1977. In 1980, the famous that Gurbakh Singh's case comes in. Bail is the rule, jail is an exception. But here in the remanding magistrate order one-liner, they are again jail custody. I think the Gurbakh has gone for a spin altogether. So as regard the other decision, my lord, for every submission, I have given the decision. So my lord, I conclude with it. And since the case diary is before Lordship, and basically what happens, I have seen the after there is a judgment also I have relied on. If it is your cases on bank transactions, UPI transactions or bank deposit or anything, and everything you have seized, and it is under 113(1)(b), nothing remains hereafter to have a sadistic pleasure of putting someone or keeping someone in behind the bar. My lord, as regards serial number 1 to other cases, my lord, for every proposition I have submitted, the judgments are already there before. I am obliged, your lord.
Lordship, we appear not only for opposing, also we had a great hope that we will learn something from my eminent senior.
I am still a student of law. No, don't say.
But my learned friend deprive us that what are the citations they have placed before this honorable court.
Hello.
Actually, when we are
I am giving my copy.
No, this is not true. Now, when we are learning and when we enter this bar, we are sitting behind the bench and with a notebook that whatever the citation placed by the senior, we keep note then and go to the home for homework.
Now, notebook is not necessary. I have given you my
Now,
book.
now that I have seen that more than almost 12 judgment has been placed, and what is the content I am yet to go. Anyway, Lordship, I am very much obliged that he has just go. And synopsis were also given. I am also entitled to that copy also.
But what about your synopsis? You were supposed
No, I
to.
have not submitted.
You are much junior to me
No.
in the bar.
No.
Although he is a colleague,
No.
everyone's for the court's convenience. That was what was taught to us by our senior.
Okay.
That if it is my duty at my age, so also is your duty to
Yes,
give
sir.
your synopsis.
But I have not made any.
And that is
because-
also provided in the Guwahati High Court Rules, Chapter 5A.
Yes, but as it is a case diary, I don't want to disclose it public till as investigation is still going on, Lordship. That is why, Lordship, I could not make the written objection in the form of affidavit as well as the synopsis, so that it can be privy to the other side, Lordship. This is my only ground. Now, Lordship, the very first line my senior friend argument that with a poem by quoted in our judgment that life is free if you are born free. But it is equally applicable for our freeness in our life. We should not keep the others people life in peril, Lordship. The public servant, which we have expectation to cause to serve the public, Lordship. Instead, if they do a contrary for their own illegal enrichment, depriving the others and putting society in a very dark situation, then this type of cases, Lordship, should be handled in that strictest way, Lordship. Not to be any privilege, not to be any others to be considered in this type of cases. So what is the case about, Lordship? Before Lordship like to draw your attention to the FIR, Lordship. Initially, FIR, Lordship would find as Page Lordship.
In, you are dealing with 32 now, 32?
Lot 32 Lordship.
Yes, FIR is at page.
FIR is page 1939 Lordship. And before Lordship FIR, I would like to submit Lordship. Initially, Lordship, in this case, one regular inquiry was initiated on 24/2/2025 against the petitioner. Lordship.
Before filing.
that. And upon receiving the one information, source information, that he is illegally gaining by serving in the outside by violating that conduct rule. It was the first allegation received by the CM Vigilance Lordship. On the basis of that, that inquiry was initiated. And during the course of that inquiry, Lordship, other facts came into light, causing rise of this FIR, Lordship.
সৰু handwritten note টো থাকে, সৰু handwritten note টো থাকিব যে।
Oh, sorry. Yeah, something from the.
মোৰ হ'ল। ইয়াতে আছে ৰ'বা। এইখন দিব নোৱাৰি।
Sir, নালাগে. Lordship, that.
Yes.
And the petitioner was accordingly that suspended on 26/2/2025. And during that period, Lordship, that preliminary inquiry was going on, Lordship. During preliminary inquiry, we had our panel chartered accountant. The IO or the any other inquiry officer has not nothing from their own, Lordship, because they were not experts. So we have our engaged panel chartered accountant who has analysis all the financial analysis details so far as came to the knowledge of the investigating authority. And during that inquiry, Lordship, more than 280%, 282.08% of disproportional income acquired by the petitioner came into light. Accordingly,
What is the percentage?
Lordship,
Percentage is?
82.08%. And one argument has been advanced by my senior Lordship that police has inquired police has taken the check period from 2019 till March of 2025. Why the prior period income could not be accommodated? Lordship, that we are concerned of a income accumulated by a public servant. He joined in the cadre of SCS in the year 2019 only, Lordship. And till March, the income derived by the petitioner from his salary is the total legal known source of income. Beyond income, he is accountable, Lordship. During trial, he will get every opportunity to disclose the allegation made by the prosecution, Lordship. Now, Lordship, may I read, Lordship, that FIR, Lordship. Other fact, Lordship, I will place and also show from the KJ also. The informant exists that Masum Yusuf Ahmed, the then circle officer of Bodali Revenue Circle, acquired huge properties by illegal and corrupt means, which is disproportionate to his known source of income. Further, he is holding dual employment, working in Infosys, while simultaneously serving as a full-time government officer in clear violation of service rules. Accordingly, RE number so-and-so was initiated at Vigilance PS as per the approval of Honorable Chief Minister of Assam, file number so-and-so. During inquiry, relevant bank statement and other relevant document and information were collected. For the purpose of calculating income, assets and expenditure, and to work out the amount disproportionate asset found in his possession, the check period has been taken from 1/1/2019 to 31/12/2024, taking into consideration of flow of acquisition of property. During the course of inquiry, all available financial documents and records pertaining to Masum Yusuf Ahmed, the then circle officer of Bodali Revenue Circle, Bodali, were meticulously complied and submitted to MS Thakur so-and-so, Guwahati, an empaneled chartered accountant firm for the thorough financial analysis. The primary objective of this analysis was to scrutinize the financial dealing of Masum Yusuf Ahmed and identify his disproportionate assets or unexplained wealth that could not be accounted for by his legitimate source of income. MS Thakur so-and-so, Guwahati, an empaneled chartered accountant, submitted financial analysis report on 27/9/2025. through mail. On perusal of the financial analysis report, it is found that Masum Yusuf Ahmed, SES under suspension, the then circle officer of Bajali Revenue Circle, Bajali, was found possession of asset, movable and immovable, to the tune of 234,837 before the check period of so and so. 2,34,807.92 before the check period, that is up to 31/12/2018. On perusal of financial analysis report, it is found that Masum Yusuf Ahmed, the then circle officer of Bajali Revenue Circle, Bajali, was found possession assets, movable and immovable, to the tune up to 3,66,37,226.04 at the end of 6th period. That is up to 28/2/2019 to 31/3/2025. On perusal of financial analysis report, it is found that total income of Masum Yusuf Ahmed, the then circle officer of Bajali Revenue Circle, from all known source is work out at rupees 1,60,75,588.35. On perusal of financial analysis report, it is found that during the check period from so and so to so and so, suspected officer Masum Yusuf Ahmed, HS under suspension, the then circle officer Bajali Revenue Circle, Bajali, incurred expenditure under different head, which is work out at 2,50,28,102.40. After computation of his income, assets and expenditure, final position of disproportionate asset is work out as under. Computation of statement of A, B, and C, asset, income, and expenditure. Asset held before the check period, A, is 2,34,807.82. Total assets held at the end of check period, 3,66,37,226.04. Income from known source of income during check period, 1,60,75,588.35. Expenditure incurred during check period, 2,50,20,102.40. Asset acquired during the check period, B minus A, 3,64,02,418.12. Likely saving minus 87,44,51,408. Thus, total amount of disproportionate likely saving is 4,56,932.20. Thus, total percentage of disproportionate asset was worked out as 282.08%. During that 5 years of less service period, this much of asset was acquired by a public official lordship, which we have very reposing faith. During inquiry, it was found that income of suspected Masum Yusuf Ahmed, the then circle officer Bajali Revenue Circle, Bajali, from all legal sources. This paragraph is that is a fiction. From the above fact and circumstances, it is found that Masum Yusuf Ahmed, SES, the then circle officer of Bajali Revenue Circle, Bajali, enriching himself illegally during his tenure of office as public servant and acquiring disproportionate asset against his known source of income in conspiracy with the others. This is important, Lordship. Hence, I request you to kindly register a criminal case against so and so. This is in connection, approval has been accorded by Honorable Chief Minister dated so and so. After receiving approval, Lordship, that there is a copy of the inquiry report of RER number so and so is also annexed along with this FIR, Lordship. And after receiving the approval from the Chief Minister, because as per Act, Lordship, it is required, Lordship, under Section 17A, this FIR was registered. And the offense alleged is, Lordship, above 7 years of imprisonment, Lordship. So, compliance of Section 35 or 41, as the case may be, is not mandatorily be required in this case, Lordship. It is not required, Lordship. And Lordship, before his arrest, Lordship, all provision of Section 47, 48 of BNS have and 35 have already been complied with, Lordship. And why he is arrested, Lordship? That's, Lordship, I'd like to draw your the forwarding report, page 48. That's it. First paragraph, that last from I would like to the region of arrest. Page 48. The last paragraph, region of arrest. That's it, got it?
Yes.
Yes. Reason of arrest of Masoom Yusuf Ahmed. Masoom Yusuf Ahmed action constitute a grave violation of public trust, for which arrest was effected, and to ensure accountability and uphold the integrity of governance, and also for the following reasons. First, named accused in FIR, the arrested individual Masoom Yusuf Ahmed has been explicitly named in the accused person in the FIR. Second, Lordship, important, attempt to cause disappearance of evidence. During the house search, Masoom Yusuf Ahmed threw a bundles of documents from the third floor towards the backside yard of their residence. The house search team, on searching the backside courtyard, found several bank account passbooks belonging to one bank checkbook bearing no showings of Mrs. Salma Ahmed containing 49 pages. This belongs to her mother. He has also opened a bank account in the name of her mother and made a transaction. And all the transaction has been made by him by giving his own mobile number. His all everything is there, Lordship. I'll go, Lordship, bring your notice to that portion, Lordship. One HDFC bank passbook bearing number so and so containing 10 sheet. One, these are the Lordship passbook they had recovered, they had thrown it away to cause the disappearance of evidence. Later on, it was collected by the team, Lordship. 3. Unexplained cash deposit. An analysis of the bank account maintained by the accused with ICICI Bank revealed that he personally deposited a total 20,72,000 in cash from January 2019 to date, despite having no source of income other than his government salary. He failed to provide a satisfactory explanation for this deposit. This indicates that funds were illegally acquired through bribery facilitated by for abuse of his official position. Lordship, may I pause for a moment, and I would like to bring the notice of his pleading, Lordship. In his bail application, Lordship, the petitioner has claimed that this 20 lakhs has been received from a land acquisition amount from Dergaon. They had an ancestral property in Dergaon, his mother's, and that 20 lakhs has been received by his mother, and mother gave him, which he deposited in his bank account. It is his. But our investigation carried out so far has revealed the contrary things, Lordship. There are evidences found that hardly 2 to 3 lakhs has been given by his maternal uncle to his mother, that not in the land acquisition, because her mother is not entitled to get any land acquisition amount, because their family property has already been partitioned and mother has no share on that acquired land. However, with a love and affection, they have just shared coping amount of rupees 2 to 3 lakhs maximum. And it is, the statement has been recorded in the case diary. Lordship may note the page 218 and 224 in the 11th page in the case diary to 218 and 224. There are two statements. I won't name Lordship now. They have stated that we have not given this much of amount to his mother. So this 20 lakhs received his claim is blatantly false, Lordship. He is not only mislead the investigatory agency, but also try to mislead this honorable court also. And next, Lordship, undisclosed bank account with massive credit. Third point, Lordship. While serving as a circle officer of Bajali Revenue Circle, Bajali district, the accused maintained an undisclosed account of HDFC Bank. Investigation revealed that his salary credit into the account amounting to only 46 lakhs since the joining of so-and-so, whereas the total credited amount in the account stood at several crore. Disproportionate asset beyond justifiable means.
A preliminary analysis conducted by an empaneled chartered accountant firm identified disproportionate asset amounting to 82% of his known source of income. This figure, which already point to significant financial misconduct, is expected to rise substantially upon the completion of the full financial assessment. This process of full financial assessment also is still going on. Pattern of bribery and corrupt practice, which is very much important and shocking. The accused has been found to engage habitual bribery in exchange of his official duty related to land mutation and demarcation. His bank transaction revealed frequent cash deposit amounting to lakhs of rupees made by himself, which serve as a irrefutable evidence of his misuse of his official for illicit financial gain. Further, digital evidence including UPI transaction and bank transfer conducted by his brother and mother and also other which corroborated his involvement in bribery. Systematic concealment of illicit wealth. At the time of arrest, the accused was actively engaged in ongoing corrupt practice. Investigation have uncovered a sophisticated mechanism for concealing illicit wealth through investment in the stock and market and mutual fund, manipulation of digital land record and personal gain. With land and revenue matters now processed through Assam government e-portal, the accused exploited the digital system in manipulate the land record in favor of those who paid him bribe, thereby undermining the integrity of government process. And this is the necessity to uphold public trust. And my petitioner, who was earlier working in the very computer company Infosys, he has very sound knowledge in computer lordship. So digital, he cannot be defeated lordship. Now lordship, before handing over the cash diary, that why he should be now retained in the custody lordship. My learned friend has submitted that keeping a person in the custody is not for any reserve for some the government or so and so. Not at all lordship. There is a modus operandi. We have a 164 statement and 161 also statement recorded from witness. It reveals how he accumulated his assets. Sometimes he asset in his own name, in his name of his wife, and in the name of some other person is a Benami lordship. That investigation part is still going on. Lordship would kindly mark the page 220, 226 lordship, 228, 229 are the 164 statement lordship. And their lordship corresponding 161 statement are at 224, 222 and 220 lordship. From their lordship would get a picture how assets were accumulated lordship. And lordship, and I have already given that regarding the land acquisition amount that 20 lakhs is contained that which is given. And lordship, now another factor lordship which his custodial interrogation is required to the investigator is that there is a information coming to the investigation that witnesses are being influenced now, and witnesses are being threatened and approached not to give diverse information before the investigating agency. Lordship would just have a go to the statement of two witnesses at page 303 and other is 224B. They were reposed by one mother and by one wife, and we will give also lordship a pen drive consisting in some video clip in the case of the next case lordship. We have some other information we have received by our source that there are some communication information passed from jail to his family member to oppose the witnesses lordship.
From jail?
From jail lordship. If that information is received by me by today evening, it is not updated. If required, we will place those information before the court also. How their communication is going on. Investigation is going on, lordship. I will not disclose much, lordship. So in that case, Lordship, that's in basis of my that objection and argument in respect of Masum Ahmed Yusuf Ahmed Lordship. The ground of the bail objection Lordship in form of bail objection has been placed, and we have a pair that and it is a part and parcel of the case diary. Lordship. I am also and that bail objection is a part of parcel of case diary. Lordship. We are not disclosing to others as investigation is going on.
What is the this one is other one, 32.
Now,
This is of 32, no? All are for 32.
32 is 32. Now, Lordship.
Just a second.
But in respect of 32 Lordship, he is the brother of petition number 1 Lordship.
33.
33. 33 is born in the ALRS cadre Lordship, Assam Land and Revenue Service cadre. He also joined in the same batch of 2019. And FIR Lordship would find at page 45. Lordship, married Lordship. I have the honor to state that a credible information was received on 30/12/2024 regarding serious allegation of corruption, abuse of power, and ethical misconduct involving Tanvir Yusuf Ahmed ALRS, currently serving as Circle Officer at Dolgaon Revenue Circle, Dorong. The allegation is about Tanvir Yusuf Ahmed being involved in corrupt land administration practice by demanding and accepting bribes from the public through his subordinate staff and broker for land mutation, demarcation of service, partition, issue of chitha or jamabandi, registration of landed document. Credible information has also been received that for every legacy data update, he would take 10 to 20,000. And for every hearing made in the miscellaneous revenue related cases, he would take 30 to 50,000 from every applicant through his subordinate staff and broker. The suspect and his family are reported to lead an extravagant lifestyle, far exceeding the means provided by his legitimate income source, strongly suggesting the existence of undisclosed and illegal financial channel. It was also alleged that he is involved in questionable stock market activities, suggesting the use of public office for personal financial gain, including bribery and misappropriation of public funds. He had also made diversion of funds through multiple bank accounts in his name as well as in the name of his family members. This account reportedly reflects substantial deposit, raising concern about undisclosed and potentially illicit income sources. Further, it is also alleged that Tanvir Yusuf Ahmed ALRS, who acquired huge assets, which is disproportionate to his known source of income. Accordingly, RE 725 was initiated at Vigilance PS as per approval of Honorable Chief Minister by order file number dated 19/2/2025. During the course of inquiry, it is found that suspected officer Mr. Tanvir Yusuf Ahmed joined as ALRS in the year February 2019 and presently he is working as a circle officer at Dolgaon Revenue Circle, Dolgaon, Dorong. During the discrete inquiry, I collected bank account of suspected officer to verify the genuineness of the allegation as leveled against him. For the purpose of calculating income, assets, and expenditure, and to work out the amount of disproportionate asset in his possession, the check period was taken from 28 to 2019 to 31/3/2025. During the discrete inquiry, I analyzed the bank account of account number so and so maintained at the SBI of Tanvir Yusuf Ahmed and found under. Okay, I would not, Lordship, take your time, Lordship. I just say. Last, the credited amount, Lordship, the credited amount 84,43,187 is more than double the total salary credited in the SBI account. Cash deposit amounting rupees 3,95,000 suspected to be ill-gotten money of the bribe. Suspicious transactions were identified, leading to query being sent to mutual fund companies, stock exchange, Glow app, and concerned bank. We have, Lordship, sent it, Lordship, but the report is yet to become. During inquiry, I also analyzed the saving bank account of so-and-so of Tanvir Yusuf Ahmed, which ICICI Bank had found under. Total credit to the bank account since 2/3/2020 till date, Lordship, 14,24,357. Total debit to bank account since 2/3/2022 till date is 13,32,653.17. A majority of credited funds were invested in the stock market and mutual fund. On obtained permission from ICICI Bank account number, on detailed examination of the ICICI Bank account number so and so revealed total debit 6 lakhs invested towards mutual fund, investment of 4,30,000 in the stock market for the same account. As per Rule 6.7 and 6.9 of the Assam Civil Service Conduct Rule, government employees are barred from trading in the stock market. These restrictions apply uniformly to employees of the central government, union territory, and state government. Several suspicious transactions were identified in SBI account number so and so maintained by Tanvir Yusuf Ahmed, consequently for which inquiry were initiated with the relevant bank for further verification. Upon receiving the necessary information, it was observed that funds in question were transferred from broker, contractual staff member of the Dolgaon Revenue Circle, his mother Salma Ahmed, lots of important, and others. The copy of the depositor's name Salma Ahmed, Murahullah, Bhargavjyoti Das, Ritimoni Das, wife, Utpal Lekha, Seja Enterprise, Ekramul Haq, Rezaul Karim, Rukia Khatun, Chinmoy Bora. Their designation amount of money laundered in prepared in a sheet and enclosed with the report, which is suspected to be involved in illicit fund potentially acquired for bribery. During inquiry, CDR and customer application form of Tanvir Yusuf Ahmed was obtained and analyzed, from which it was found that sufficient investment in the stock market through Glow share market app, substantial mutual fund investment using ET money, suspicion of undisclosed bank account of ICICI, HDFC, IDBI, and Punjab National Bank. During inquiry, a saving bank account of Salma Ahmed, mother of Tanvir Yusuf Ahmed, maintained with the HDFC Bank via account number so and so, was collected. On analysis of the same, find the following fact emanated. Total credit to the bank account since 22/4/2004 till date 24,04,615 rupees. Total bank debit to that bank account since 22/4/24 till date 22,42,621.94. Total cash deposited in the bank account since 22/4/24 till date is 6,40,000. It is observed that several employees of the Circle Office Dolgaon have transferred funds to Salma Ahmed, Tanvir Ahmed, mother of Tanvir, in HDFC Bank account number so and so. Additionally, a cash deposited 6,40,000 was made into his account. He took money, Lordship, in the name of his mother's account. These funds are suspected to be proceeds from bribe allegedly collected from the public for subordinate staff and broker in exchange for service related to land mutation, demarcation, partition, issuance of Chita, Jamaboni, and registration of the land document by Tanvir Yusuf Ahmed and deposited in the mule account in the name of his mother. During inquiry, it was discovered that Bhargavjyoti Das, a contextual computer operator at the Dolgaon Circle Office, has transferred a total amount 4,20,000 across 6 transactions via UPI to Salma Ahmed. the murder of Tanvi Yusuf Ahmed alias. This transaction raised strong suspicion of being a conduit for bribery, potentially intended for Tanvi Yusuf Ahmed through his murder. During the course of inquiry, it was revealed that Mr. Tanvir Yusuf Ahmed, holding the position of ALRS Assam Land Avenue as the circle officer of Dolgaon, Dorong, made stock purchase of total 97,000 so and so. Additionally, there are suspicion that he may be used a different PAN number linked to another account for trading activity. This raised concern about the possibility of undisclosed financial dealing. This aspect of investigation is still going on. During the inquiry, all available documents related to Tanvi Yusuf Ahmed, such as the bank account detail, IT return file, were submitted to the MPNL Chartered Accountant, MS so for financial analysis. The Chartered Accountant firm was tasked with auditing and document to identify any disproportionate asset. Accordingly, Mr. So submitted a preliminary report on 17/3/2025. On perusal of the financial analysis report, it is found that suspected officer Tanvi Yusuf Ahmed, ALS, was found possession of assets movable and immovable to the tune of rupees before the check 2.6 rupees. There is some mistake, I think. On perusal of the financial analysis report, it is found that suspected officer Tanvi Yusuf Ahmed, ALS, was found possession of assets movable and immovable to the tune of 14,15,496.60 at the end of check period. On perusal of the financial analysis report, it is found that total income of Tanvi Yusuf Ahmed from the known source of income is work at 40,29,282 so and so. On perusal of the financial analysis report, it is found that during the check period from 28/2/2019 to 31/3/2000 so and so, Tanvi Yusuf Ahmed has incurred expenditure under different heads, which is worked out as 1,05,56,699.33. On computation of his income, assets and expenditure, and financial position of disproportionate is worked out at, let's make directly up, total 97,42,913, which is percentage of disproportionate lordship 197.12%. Lordship 197. 79 lakhs. Sorry. During inquiry, it is found that income of suspected officer Tanvi Yusuf Ahmed, ALRS circle officer Dolgaon from all legal source is rupees 40 lakhs. This is in the same in verbatim lordship. Hence, I request you kindly to register a criminal case against suspected officer Tanvi Yusuf Ahmed, ALRS Dolgaon and other under the proper section of the so. This is in this connection, approval has been accorded by Honorable Chief Minister dated 23/2025, submitted forward. A copy of regular inquiry report is annexed along with so. In this case also, Lordship, we have a prima facie case of accumulation of disproportionate income of 197.12%. In other cases also, the prima facie case is of the investigating agency of accumulation of disproportionate asset of 282 point some Lordship. We have a prima facie case. That's why, Lordship, they have been took into custody and all ground of arrest as required under by law and reason of arrest has been duly communicated, Lordship. And Lordship, would find his the forwarding report at page 56. Lordship, I will not read, Lordship. That's same thing. That I'm just reading that name accused in the FIR to the region, attempt to cause disappearance of the evidence. He also throw it out his all the passbook and so, and habitual bribery and misuse of official position. He has also unexplained wealth, cash deposit in bank, Lordship, and disproportionate asset 197.12%, the concealment of illicit wealth and manipulation of digital land record, and restoring public trust and prevention of further corruption. His arrest was imminent and he was, Lordship, arrested, Lordship. Now, Lordship, page 59, Lordship, I just Lordship, no, page 68, Lordship. His bail rejection order, Lordship.
Yes.
Sorry, Lordship, his bail was ultimately rejected on Lordship 10/4/2024, Annexure 10, page 70, Lordship.
Please.
Page 70, Lordship.
70.
70. His bail rejection order dated 10/4/2024. I would in the Lordship, the page 11 pages is 71, Lordship. Third paragraph. I have perused the case diary. Perused the case diary and found that the IO has collected incriminating material against the accused. There is also allegation against the accused that he threw a bundle of documents from third floor of his residence toward the backyard of an attempt to cause disappearance of evidence. I found that there is necessity for further investigation in this case, and releasing the accused on bail at this would hamper the investigation. As such, bail of the application filed against on bail is rejected. And this is still prevailing. I will just throw it from the case diary. Like like other case, I like to let's give the page number of the relevant witnesses in this case.
Yes, just give us.
Let's say there is evidence of demanding iPhone in lieu of cash, Lordship, and he has purchased.
This time he wants iPhone.
I don't have, Lordship. Pro Max, Lordship, 1,50,000. Lordship, there is a 164 statement, page 466 and 467, and as well as 300. These are the two witnesses we have examined, who has given and from where it was purchased. Page 300 is the person who has given that iPhone in lieu of dog. And page 466 and 67 is the shop owner from where that iPhone was purchased. And their corresponding, Lordship, 161 statement Lordship would find page 457 and 286. And regarding the land purchase claim, same claim has been raised, Lordship, that they had 20 lakh and so from. That was not correct, Lordship. That page 481 and 459, Lordship. They have clearly stated that no amount was given. The total amount of
who is the witnesses now here?
Witnesses were the relative from
No, whatever the page number.
Page number 459 and 481. Two witnesses, Lordship. 459. And Lordship. 451. Oh, sorry, 459 and 481. And Lordship, on behalf of the petitioner, Lordship, or on be for same Lordship, that there is a statement, Lordship, 459, Lordship would find that he has been or she has been opposed not to disclose all these details to the CMP. I have already marked, Lordship. Still 481 or 450. And another important statement Lordship would find, one is from 189 page, related to bank transaction. And 182 and 184, how they are collecting money and for what purpose and how it was obtained, everything it will be revealed, Lordship, in those statements. There are other statements also, Lordship, in the case diary. Lordship would go through, but these are the main important statement I will highlight, Lordship. Considering the time constraint of the Honorable Court, Lordship, I will not take you, Lordship, too much. But another, Lordship, one, I was sharing a pen drive, Lordship. There are some voice clip intercepted legally with permission from the appropriate authority, Lordship. Yes, it can be used, Lordship. Lordship, if you got time, Lordship, to go through that video clip, I have also given a transcripted file also. What was their dealings with the middlemen, how it was collected. If 10,000, 20,000, suppose Lordship 20,000 has demanded, he has given only 10,000. Then work has been delayed for one or other reason. Put up it for hearing. সেইটো হিয়াৰিঙত পেলাই দিয়া এইটো পিছত চাম আমি কিমান দিলে এটি দিয়া নাই না এইটো পিছত ৰাখিম these are the conduct of a public servant and they are seeking before this called leniency in the 21 days of their custody. The huge network has been spread all throughout during their jurisdictional area to collect the money and getting for illegal enrichment, and now they are showing them they are very meritorious. They have left their job for their job, and these are the sacrifice that you have given, Lordship, made, Lordship. So, Lordship, I have given, and other thing, Lordship, I have not
They
disclosed.
sacrificed their meritorious careers.
Meritorious career for this type, Lordship. So they are not getting any leniency, and this. Yes, and though, Lordship, and these are the economic offense, Lordship, I have not argued on that much, and these type of cases are the class apart, as Honorable Supreme Court has time and again stated. Only prima facie case. No, we have already mentioned there. We have, Lordship, prima facie case. And the judgment which my learned senior friend has cited has no relevance in this case. The last judgment 195, which he started with a poem, Lordship, it was a case of preventive detention. Yes, Article 21 is important, but at the same time, interest of the society is also be looked into, Lordship. If you are delaying a land mutation work for more than months, Lordship, does it not a violation of Article 21 to those persons, Lordship? Those needy person who approach, Lordship. Lordship, I am also my love victim. I have also applied my one partition case, but still it is not materialized because I have not approached him, and he also might not know that I am also an advocate. I have not disclosed my identity also. Still, these are the facts going on. I am not generalizing, Lordship. So far as this is concerned, there are ample material how they have exploited the society. Article 21 is both sides, Lordship, not only in the side of angle of that petitioner only, that who are languaging here for only 21 days. And the preventive detention scope is, and the normal bail is quite different, Lordship. And certainly, until, yes, we also do admit that proposition of law, but in this case is not, no applicability, Lordship. Ernest Kumar is also not applicable in this case, Lordship. Yes. So these are my humble submission, Lordship. If my learned friend anything you have reply, if I need to reply, then I will have the liberty, Lordship. We have being a renewal, we have some privilege to my then
This time is rejoinder is the last.
no, sorry, beyond city I cannot speak, sir. You have the liberty.
Prima facie case. Lordship will look at page 45 of the item number 33. What kind of application of mind I will show what is prima facie case.
You're on 33?
Yes. Sometimes a feeling is made out. I also get confused whether it's a real case or not. But the hypothesis, your Lordship will see that standard of application of mind for making out a prima facie case in the language of my learned colleague. Lordship will look at page 45, paragraph 12. Has your Lordship got it?
Yes.
Mr. Tanbir Ahmed joined as ALRS in the year so-and-so, and presently, your Lordship will kindly underline the word. Presently, he is working as Circle Officer, Dolgaon, Revenue Circle, Dolgaon. Have your Lordship got it?
Mhm.
Now, your Lordship will come to page number, this particular page number 56 of the forwarding report. First sentence. This is how he was forwarded. Presently, the accused is first three line. He is working as Dolgaon, as your Lordship got it. The whole hypothesis, the prima facie case. Now, your Lordship will kindly come to page number 41. This FIR and the forwarding report, and before that, what happened? I was
41.
transferred to Nagaon because my wife was from the same district, Sipazar. That was the cause of my transfer at page 41 on 9th of January 2025. I got married on 18th of December. 9th of January 2025, I was transferred out after the marriage. Now, that particular feeling.
You got transferred to which district now?
No, in Samaguri. That is the transfer order. Now, in paragraph 12, the FIR and the forwarding report, it says I'm still working in Dolgaon. And his enquiry is made in Dolgaon. Has your Lordship got it? The enquiry started in March. And it is no reference to that anything about Nagaon district. He's speaking about Dolgaon. I am from Dolgaon, I left Dolgaon. Initially, after marriage, what happened? Let me be very fair to your Lordship. I came to the High Court against this transfer order on the ground of that I have recently got married. I should not be. And that writ petition was immediately dismissed. And I had to join Nagaon district. And thereafter, this drama began. My second reply, that Apex Court judgments I have, if it is not 13(1)A, 13(1)B case is registered, enrichment for yourself, in that case, they have fixed a term and period and a starting period. They have not calculated because they are panel, what is called not panel advocate, it is called panel chartered accountant. How much I accumulated. Second is, they have not also stated that when two sons are there and the parents here, for the most probably one who suffers, they understand, because at my home I have seen, when a person suffers from a cancer and a heart ailment like stent, how much money has to be deposited to the parents' account from time to time, because it's a costly affair. And that has been now taken as a bribe money. They are trying to put it as channel, and the whole hypothesis is from Dolgaon. Now, Apex, lastly, my lord, I will not take your lordship's valuable time. Apex Court has said, from the forwarding report as well as the FIR, they have already stated, I'm sorry, lastly, my lord, in the FIR as well as in the forwarding report, in both the cases, they have stated, we have compiled, seized and compiled all the bank passbooks and bank accounts. Word is compiled. After this seizing and compile, what happens? The Apex Court has already laid down that once you have compiled, nothing is to be seized now. So far it is document. Then there is no point keeping someone behind the jailer. If you can give a stringent condition that come and explain now this account, come and explain that account, that I have already referred to my judgments. once you have ceased, if you need any further questions, that you can call. Keeping a person in jail custody to see the fun of it. And another more point I have forgotten. Here is the first case, 32. His wife was also an interreligion marriage. Fortunately, he got married 10 years back. Now they have a child of 1.5 years old. Looking after the parents-in-law at home. And they wrote a letter that they were given notice. She wrote a letter that my mother-in-law is so-and-so with all medical reports. Medical reports are here. And if you want to investigate anything or record statement, please come to our residence and record. That is because the Lordship is aware, if the notice is violated, then they get a good ground for arresting this person, ladies also. This is my submission. I'm on that. Yeah,
I have nothing to reply, just only to read that the IO case was according to him, he stated that after the High Court case, this case was initiated. And IO in his report has stated that he is still at Dolgaon.
Joining report also.
Yes, sir. Yes, because Lordship, his inquiry was conducted during his tenure at Dolgaon. IO has nothing any business regarding his transfer to any other place or High Court case. It shows that IO is impartial. Had there been any knowledge of that High Court case, for this High Court case, this case was initiated, then IO would have mentioned that he has been transferred, he has filed a High Court case. That knowledge must have been born in the mind of IO Lordship. IO had no knowledge that he has been transferred, he has filed a High Court case. So it is shown a very good impartiality of IO Lordship. And second Lordship, for cancer patient whose mother money was deposited. Yes, we have got sympathy, but thing is that money was deposited in mother's account, and from the mother's account again the case transfer was to his own account. This is the irony, Lordship. And intelligence made, Lordship, I have already explained, Lordship. Even Lordship is assuming that his allegation is correct, Lordship, we will have to project whether the allegation leveled by the investigation is true or not is revealed by the record. This is my submission, Lordship. We have no business with the intelligent marriage of the party. So, so investigation is still in this type of cases very nascent stage, Lordship. So at this stage, Lordship, his bail payer may not be considered and bail payer may be rejected, Lordship. Obliged, Lordship.
Oh dear. We are obliged.
His wife took 2 weeks time to appear before the IO. He wrote a letter.
No, she was.
Wrote a letter with the enclosures. Wrote a letter with the enclosures, not my wife. That Masum, other brother's wife.
You are representing both.
My wife is still after retirement enjoying her life. She has retired long back, but she is keeping good health. His wife wrote a letter that my mother-in-law, who is suffering because every time that thing, and 1.5 year child, he had to be admitted in hospital, saying that please come and investigate us. Now the police is always police. I will not comment further.
No, police has granted.
Always don't confuse with wives.
Police has granted 5 days time.
Because prosecution sometimes confuses everything. I'm obliged to you.
Yes, sometimes it happens. We also ask sometimes. Your wife, his wife.
My wife will be very angry with him. Because
I don't want to
she
watch
being in the
snacks and tea in his
she
room.
being in a teaching line, she is necessarily unlike me. And the drop of a hat, she loses her temper. After going back, I will say that so and so has said that you have done this.
It is my normally I pay before the court. Now my last page before the sir.
Last-
Not to disclose before
Last
court.
shot was very bad shot. That his wife. My lord, we are obliged.
Obliged.
Is there any other?
Pardon?
No, that we have. to
No,
wait.
we have some.
Obliged.
This is charge sheet case, my lord.
No one, this is POCSO case.
POCSO case, my lord.
Okay,
ma'am.
okay.
And sorry.
Because some matters may be adjourned to the other matters
lord.
because we have already kept reserved for 4, 5 matters, 6 matters or 7 matters are there. So we're not going to hear other matters. That's what.
It's
It is a case of POCSO.
My lord.
service not complete.
Service not yet completed. So I have read it. Services, yes.
Last 2 occasions, my lord, this instruction awaited for the instruction service report, my lord.
Instruction service not
Lordship may
complete.
Services not completed. Why? What was the reason? Is there any?
My reason that has not been mentioned, my lord, because I was told from my office member that they tried to contact the IO member, service is not completed. Or lordship may please just then appoint a.
You can appoint amicus otherwise, because service, how many weeks you wait for service?
Lord, even my lord, trial is on the path of conclusion, my lord.
Oh, acha, acha.
Short date may given.
No, we don't have short dates. Problem is there. We don't have short. Heard Mr. K.M. Hassan, the learned counsel for the petition. So heard Mr. R.R. Kaushik, the learned additional PP appearing on behalf of state respondent. From the office note dated 7/4/2025, it is seen that the scanned copy of the LCR has already been received, but the service is still awaited for the response number 2. Post. Next part. In that context, Mr. Kaushik, the learned additional PP submitted, he made an inquiry regarding the service of notice on response number 2. However, it is informed that they could not, I mean,
That aspect I'm not aware.
they could not inform that the service could not be, no, the notice could not be served on the response number 2 till date. Considering the case was, it is seen that this is the 3rd date for the awaited service where the service is awaited. But response number 2, hence, this court is of opinion that an amicus may be appointed to represent the response number 2. Yes, whom can be appointed now? D. Sakya. Accordingly, MS D. Sakya be appointed as an amicus. Poster, registry will do the needful. List the matter accordingly when it can be listed. Yes.
Second week of
No, we don't have 2nd week of May. You have to go on 3rd week of May.
19.
21, 21, 5.
My lord.
Okay, 20.
Okay.
Mr. Bhattakur, how are you? You are in busy in which court now? Court number 11.
My lordship.
Dealing with all the cases with the grounds of arrest, we will now be. Anyway, yes. Item number 21, you are. Yeah.
Lordship, here,
Yes, sir.
I did a mistake.
There is some mistake in your
Yes,
application.
On petition, yes, yes, lordship. You know, earlier rejected bail order, I have not annexed there.
You have not annexed the earlier bail order rejection of the bail
Rejection
order.
of bail order, yes.
Okay, then you can annex the said order with an additional affidavit. File an additional affidavit, and an additional affidavit may be accompanied with the bail rejection bail order. We will note it down. Next date of listing, you just file it. Okay. You are MS? A Goyari. You are MS?
Anuradha Goyal.
A Goyari. Hard MS A Goyari, the learned counsel for the petitioner. And it is, and also heard Mr. R.R. Kaushik, the learned additional PP appearing on behalf of state respondent. It is submitted by MS Query that inadvertently the bail rejection rejection order of the bail is not annexed along with the petition. Accordingly, she said that that she may be allowed to file the rejection order. Full stop. Prayer allowed. The petitioner is at liberty to file the order of rejection order of the bail through an additional affidavit on or before the next date of listing. List accordingly when it can be listed. Is it charge sheeted case, Mr.? 2 weeks, list after 2 weeks. So you file an additional affidavit through that you can file. Okay, list after 2 weeks as to be date on which by the registry.
22.
May I please, Your Lordship? Also, this is a 483 bail application for regular bail, my lord. A petitioner is a lady who is behind the bar since 47 days as on today, my lord. And there
It's
is
a case of intermediate quantity.
Intermediate, 21B.
Yes, any information whether FSL is collected?
FSL not received.
Not yet collected. So on the last occasion, most probably it was directed that
Yes, my lord, it was
FSL to be collected.
fourth time of listing, my lord. And 47 days
47
already,
days.
already in behind the bar, my lord. Considering the length of detention, she may be released on bail, my lord.
Otherwise, any
condition.
materials are there available
Recovered for her.
for her only. She's a peddler, I think.
Peddler.
Lots of women are there in the peddling. They are engaged fully
Totally.
from yes, from even from Manipur, Meghalaya. They are also.
Whatever I have seen, most of the big cats, my lord. And those are mainly women.
Yes.
From Nagaland and Manipur.
Oh, yes, yes. They engage. Yes. They're fully involved.
Yes, ma'am.
And Rabia Begum, she has earlier case also, no?
No interest in my lord.
Huh? I
To my
heard
knowledge,
this
no
name
interest in
earlier.
To my knowledge, my lord, no antecedent here, my lord.
Obviously, there will be some incident.
She is from Mongolia, my lord.
Whatever.
Not
Anyway, we can consider just length of detention. Heard Mr. Yu Khan, the learned counsel for the petition. And also heard Mr. R.R. Kaushik, the learned additional PP, appearing on behalf of state respondent.
Habitual offender, my lord.
Habitual.
Yeah.
That's what I'm saying. So and so, and also heard so and so Koidula. This is an application on section so and so in connection with so and so. Say CD received, but it is submitted by Mr. Kaushik that the FSL is yet to be collected by the IO. And in that context, Mr. Khan, the learned counsel for the petitioner, submitted that the petitioner is a lady and she is behind the bar since last 47 days. And thus, the IO got sufficient time for her custodial interrogation. However, she is ready and willing to cooperate the IO in further investigation of this case if she is released on bail. Post. Next paragraph, Mr. Kaushik, the learned additional PP submitted in this record that there are sufficient incriminating materials against the present petitioner, and the contraband was also directly recovered from her possession. And apart from that, she is also a habitual offender. However, it is a fact, however, he submitted that the IO could not collect the FSL till date. Next paragraph, considering the submission made by learned counsel for both sides, without going detail into the merit of the case, so it's fully. To whose satisfaction it has to be?
CGM Kamrup Metro Board.
To the satisfaction of CGM. But inside the jail now, every facility is there, so she may come again. Yes. Okay.
Deeply.
23.
23 is also charge sheeted efforts or
Charge-sheeted.
POCSO it is?
POCSO case, charge sheeted.
POCSO.
Service not complete.
Not completed. None appears on call for the petition. Ms. Poster heard Mr. R.R. Kaushik, the learned additional PP, so and so. From the office note, it is seen that the service is yet to be completed. List the matter accordingly after 1 week, as on a date to be fixed by the registry.
26.
May I please, Your Lord. 26, my lord. LCR not received, my lord. Perhaps.
You copy this every day.
Yeah, my lord. Kindly pick the date, my lord. Convenient to your lordship, my lord. Any date. Reminding the records.
Scan of full stop, or you can equally online. Office note dated 30/04/2025 reveals that the scanned copy of the Trial court record is still awaited. Issue reminder. The registry will do the needful. List accordingly. 21.5.
Declare.
27.
Making sure lordship, as per last order by its honorable court, we have taken steps on the informant lordship. And the LCR has not yet come lordship,
But the service is also still awaited.
or still awaited.
You can take some instruction. It is a charge sheet case or not a charge sheet?
Third city, lord.
Charge sheet.
Yes, in the custody, the judicial custody, for 220 days.
20 days. Case is at the stage of evidence now?
Evidence, and the PW and the informant and the victims, part is.
Already
Okay.
ready.
27, no?
27.
Heard Miss, you are Miss P.
P.
Bora.
Borwa.
P. Borwa, the learned counsel for the petition. Also heard Mr. R. Kaushik, the learned additional PP, so and so. From the office note dated 30/04/2025, it is seen that the scan copy and the service on the respondent number 2 is still awaited. In that context, Mr. Kaushik, the learned additional PP, is hereby asked to take necessary instructions from the concerned police station regarding the service of notice on respondent number 2. When it can be listed, you just take instruction, we'll appoint them, then so we can make a short date, 13 or 14? 13? 13, okay. Please take it.
Okay.
28.
May I please lordship, we could not file our affidavit lordship, kindly allow us 1 week time. Lordship, my senior is coming.
No, we are not going to hear the matter any point of time. He is representing.
YS Manan.
Time being? Time being, no time. No time for time being. That's what, no time for time being. Now she is saying that they needs 1 week time for this, to file their objection. That is her submission.
Already earlier occasions, time has been taken.
Due to some difficulty, we could not file our affidavit lordship.
Let us give 1 week time her. Because otherwise also we're not going to hear the matter. Matters we are not going to hear. Mr. Mannan, we are not going to hear the matters because 5 matters today already listed. We are going to dictate all this. So in that context also, we are not going to hear. Apart from that, she is also seeking some time.
Anyways,
Your
my
two
other
matters-
matters, I have already, my junior friends have already mentioned those. There were three matters. Only this was there because we did not meet them in the morning. Anyway, on that
Your
case,
2-3 matters most probably got today adjourned, no?
today, your lordship, that day fixed 3-4 matters.
Yes.
Most
Why
of the-
you got why these were adjournment was prayed?
Yes, your lordship, because your lordship, that case, that day, I argued practically the whole matter. So I thought that let the judgment come.
So
then
we have
can-
already I have completed my dictation for those 2 matters. One with MS Bonica was there and Anna Banta was there. Those 2 are there. We are going to list on Monday, I think. Most probably, I'm not sure. And today also 4-5 matters are there. So dictation is yet to be completed. So hopefully maybe on for 5 Monday, Tuesday. So that's why we are going
That
to
is-
adjourn this one.
That is the reason actually making the same submissions again and again not make any sense, because if your lordship passes an order, then it will be easier for us also. That's why I said that let us take because this is with NCB. So that was the reason.
Easier for you to approach this court or to Supreme Court. I don't know.
No, in fact, the lordship remembers I have that day mentioned about one matter before Justice Kaushik Goswami. That judgment have come today. We have not got a copy, but he has, in fact, in that judgment, while reading the judgment, he on the operative part, Justice Goswami has informed I think, Chief Secretary that something has to be done, because otherwise, since it is a fundamental right, court has no other option. But
Now, see, sir, the police, what to do about the police? Now, actually, first order I had passed most probably 2.5 months there. Maybe
Yes.
around 3 months or 2 months.
Yes.
Then in that case, I had sent all these
Yes.
things through registry to Home Secretary and all.
Exactly.
But thereafter, I was told that there's some sort of this development is there, and they now again same thing is they are doing.
No, no.
Then
these
47 they
these-
are
no, no.
47 doing,
No, Lordship,
48 they are not doing.
No, no, these
So
are,
these things
I
are-
think, old matters.
No, all
Subsequent
matters
to
I don't know.
3 months.
Subsequently also I have found now.
Is
I
it?
have come across.
Is
Yes,
it?
yes.
So
So
the-
if these things are going on, then what to do?
In fact, Justice Midul Kalita has also given a similar. Your
Yes,
Lordship,
he also,
directive. Yes.
I know.
Yes. But even then they are doing.
Even then, I had recently yesterday or day before yesterday yesterday most probably, and today also I received 2 matters.
Very
Partly they have done. And one matter is very surprisingly, the grounds of arrest, it was a case of NDPS, and the grounds of arrest that she got pregnant within one and all. These things are there.
Very
So they was the
pathetic.
most probably cut
Very
and paste.
pathetic.
Very. On
Yes.
merit, if a bail gets it, no, we are nothing to say. But these are
Absolutely.
the things we are doing.
We are also, Your Lordship, as an officer of the court assisting Your Lordship. We are going by the law. Now, if somebody is violating the law, Your Lordship cannot help it.
Definitely.
And if they do not violate, then obviously Your Lordship has the handle to say, yes, where is the violation? That is basically everything. That's
Okay.
Anyways, he's
So
taking time.
one week time.
Ketia Diba? Next Friday.
Next week.
What?
Friday. Next
What?
Friday. Next Friday.
Friday. Next Friday is
9th. 9th.
9th. 9th you are going to submit 9th.
9th.
Okay. List on 9th. So and so, enabling the respondent NCB to file their written objection. Okay.
If Your Lordship do not mind, just one thing, that they have submitted the, I think, their objection part along with
Already?
the judgment. In that case, that they.
Other one.
Uh-huh.
Yes.
Mr. Kayal was there.
Yes.
I think they have submitted, they given me a copy.
Yes.
That I have gone through those. Your Lordship, what my learned friend said on that day, that there is an absolute bar. That is, Your Lordship, in those submissions. What I found, Your Lordship, was that it was basically on section 37 of the NDPS Act. And secondly, they have stated that violation of Article 21 will depend on the court's decision on a particular fact to fact. There was not a single case of section Article 22. I was surprised. I told my learned friend should know. But he said, no, there are judgments. That's why I'm just, this is not the forum, but I'm just making a. Anyways.
So with me, I have already done.
Masu.
34 and 35.
34, 35, sorry, CD not received, madam.
I'm on interim, Lordship.
In both the matters.
Lordship, in both the.
Earlier CD was there, after that CD was called for, actually, after that CD not received. Same case, no?
CD to that is CD
No, same case, same affair.
CD not received. To reminder. And interim be extended till next date of listing. List accordingly when it can be listed.
My lord from Gwalba, my lord on 16, 15, my lord.
No, not on 15. 15 lots of matters are there. Maybe 21, 22.
My lord, yes, 21.
You dare on interim, I think.
Interim may be
Oh, your interim is continuing up to 21/5. By listing it on 20. Kim. Yes.
36.
In this case.
You also in 36.
In this case, my lord, CD available, but it is not updated since 1st of March. He's an interim, my lord. Interim was issued on 5th, my lord. On updated CD maybe, my lord. Otherwise.
Last entry is on
1st of March.
1st of March.
So 1st of March. So 2 months it is not updated, my lord.
Okay, Mr.
Lordship.
Chaudhary.
Okay, in this case, Lordship may peruse the order dated Lordship 5/2/2025.
5/2.
Lordship.
Yes.
I'm sorry, Lordship, 3/3/2025, Lordship. 3/3, in last part, Lordship.
Just a second.
Last occasion,
Yes,
Lordship, the
3/3.
learned PP raised an objection regarding, Lordship, the maintainability of this application, Lordship. There
Oh.
is a bar under section, Lordship, 30 of Assam Uchin.
Oh, it is witch hunting matter, na?
Lordship, this matter, Lordship.
Oh, that
Last
has
occasion,
to
Lordship,
be heard. In fact, it's a witch hunting case wherein the application for anticipatory bail is not maintainable.
Lordship.
That was the submission.
Lordship. Last occasion, Lordship, we have submitted the.
Who was there in that, and that day most probably
RT.
RJ Borua was there.
Lordship.
In fact,
Lordship-
yes.
Lordship directed us to submit, to furnish the judgments of which we submit, Lordship. We only furnish them, Lordship.
Oh.
Okay.
The copy of the judgment have you have already furnished to them.
not gone through this, just only I have checked the CD. Is not updated,
Because if there was some statutory, as per, they don't know, but most probably there was some observation made by the Honorable Supreme Court
SCST.
also in SCST, where is
SCST.
also AB is barred, anticipatory is barred.
Lordship.
So where that principle can be applied for, in this case, that was the issue, I think. na?
Lordship.
Okay,
And recent judgment also there, Lordship.
okay, you make the submission on your basis of your judgment on the next date of listing
Lordship.
in
Lordship
availability
may
of
fix the
pleading.
date, Lordship. In the meantime, interim may be maintained.
It is submitted, heard Mr. R.R. K.K. Parasha, Dilanet additional PP. And also heard Mr. Ayu Chaudhary for the petitioner. 84 stop. It is submitted by CD is received, but it is submitted by Mr. Parasha that the CD is received, but it is not updated one, and the last entry is 1/3/2025. And accordingly, he submitted that the updated case diary may be required, will be required. Return the case diary, calling for an updated one. List the matter accordingly on 22-23 কিবা এটা হ'ব আৰু না? 23/5 23/5 so and so, and interim be extended till next date of listing.
Review.
37 charge submitted.
Are you on interim there? You were an interim.
Yes, Lordship.
So in that case, we are extending your interim till up to 15 days. Another for 15 days, so that you can appear before the learned trial court below with an regular application for bail. Okay.
Lordship, matter may be fixed on 29th of May.
No, it will be disposed of.
Oh.
What I'm going to say, you are on interim
Yes.
earlier.
Yes.
So that interim will continue till 15 days. 15 days means we are going to dispose of the matter. We'll give you a time for 15 days.
Yes.
So that you can appear before the learned trial court below
Yes.
with an appropriate application for bail, which may be considered in accordance with law.
Yes.
And in that regard, till 15 days, your interim will be continued. So no coercive action shall be taken against you. That is the order.
Yes, number is 30.
Yes, sir. CS number
30/25, dated 30th of March 25. 3003/25.
Okay, otherwise it will be disposed of.
This is
Parasari is in which court now?
My lord, now in court number 24, earlier few weeks in court number 3.
Court number 3. Court number 3 is the, I
This
mean, Parasari is
2
not
weeks
available.
absent, now
Yes.
court number 24. my lord.
Next week also, most probably
Most
will be
probably
not here.
absent.
The 2 weeks they are in Arunachal.
Fine.
Yes. So we are Mr. Goswami and I am dealing with this such a
My lord, that is-
this morning, and then again Kaushik raised the issue of Cotton and then whole day.
Now
We are on that.
Today, one judgment has come, my lord, to what given my lord,
Justice Goswami.
Yes, yes.
Okay.
It-
Just, I should not ask, but to what was the, it was allowed or rejected?
Allowed.
Directions were given. Okay, there's some direction parties there. Obviously, very strange. Now it is, yesterday also and today also I have received 147 is complied with, 48 is again, it's not there. And if you go by the order of that Bihan Kumar, in the second part, there's a very specific order is that 48 has to be complied with. Both. Yes.
In some of the cases, I argued that because Bihan Kumar recently on the basis of the Pankaj.
Bansalan.
So my Pankaj Bansal judgment was delivered on 4/10/23. So thereafter Bela MTV specifically states that the effect of Pankaj Bansal should be prospective. If prospective, then the arrest before 4/10/23, then regarding those punishing counts of arrest in writing those provision would not be mandatory.
Yes, that submission was made by Mr. Kaushik also. I have noted down. But there are some observation we cannot, you cannot, because unless because it's the order of the constitutional court, unless there is an order, specific order, that is in, suppose in Pankaj Bansal, then it will be treated as a retrospective, prospective, whatever. In that case, what to do? That is demanded.
Hope for recent days, some judgment.
Some judgment make.
Some support from us.
Yes, obviously. That's what we are also thinking of. We need your support and all. But apart from that, legally, we are sometimes.
Some hardcore criminals in NDPS.
My goodness, hardcore criminals means we are the Sri Bhumi jail is almost empty.
From the POCSO cases.
Yes, I have also seen. Yes, very, very dangerous game. Yes. He has already committed murder of the informant. Yes, he committed murder, I think. Yes. The NDPS, the matters which we have already releasing some this, their attendance will not be there. All the matters will be delayed in disposal. No one will come. No one will come. I just rest assured. No one will come. But what to do? That is. Earlier to that, still then 2.5 years or 3 years they were there. But now if it goes before charge sheet also, then okay, good for everyone. So we'll do it.